Ben konuşmaya başladığımız zaman başlayabiliriz. Siz galiba şu anda yayını verdiniz.
Bana mı hitap ediyorsunuz Rona Hocam? Ha? Bana mı?
Yok hocam. Şimdi
Evet, peki.
YouTube yayınımız başlıyor hocam.
Peki başlamamı mı istiyorsunuz?
Hocam başladık. Ben şu an çok ufak bir giriş konuşması yapacağım. Ondan sonra çekileceğim. Merhaba herkese iyi akşamlar. Ben
onu bekliyorum. Siz buyurun.
Merhaba herkese iyi akşamlar. Ben Hukuk Alemi Genel Koordinatörü Bahadır Bozca. Hukuk Alemi olarak İstanbul Gedik Üniversitesi işbirliğinde düzenlediğimiz Türkiye'de ve Amerika'da yargı sistemleri programımıza hoş geldiniz.
Honorable guests, distinguished professors, dear participants, we would like to welcome you all to our conference on judicial systems in the US and Turkey, organized by Istanbul Gedik University, Platform of Hukuk Alemi, and Istanbul Gedik University Comparative Law Research and Application Center. Today, our conference will take place in 2 sessions, and I would like to kindly remind you that all participants can follow the English broadcast from Gedik University's official YouTube channel, and the Turkish translation is currently being broadcasted from the official YouTube channel of the Platform of Hukuk Alemi. Our participants will be able to direct their questions both in English and in Turkish to our honorable speakers through these channels. In our first session, Professor Dr. Rona Aybay, head of Istanbul Gedik University's Law Faculty's Department of General Public Law, will deliver the opening statement, and in this session, honorable justices of the Washington Supreme Court, Deborah Stephens and Barbara Madsen, and the retired judge and currently the senior corporate counsel of Microsoft, Roger Rogov, will deliver their speeches on the US judicial system. And this session will be moderated by the Children's Representation Program Manager, Judge Pro Tem Ms. Jill Mallat. Now, not to make our participants wait for a longer time, I would like to respectfully invite our distinguished Professor Dr. Ronay Aybay to the floor to deliver his opening statement. Thank you, Professor. The floor is yours.
Thank you very much. I hope I can be heard. There's no problem with the sound system. Okay then, good morning to honorable justices and distinguished colleagues from Washington State, and good evening to dear colleagues and students from Turkey. It is my pleasure and honor to welcome you at this gathering of lawyers, between whom there's 10 hours of time difference. However, whatever difference between us exists, we are all lawyers and we are ready to participate in a legal discussion of high-level quality, I hope. I would like to express my gratitude to my old friend, Jill Mallat, for arranging contacts between Washington State's judiciary and İstanbul Gedik University Faculty of Law. Dear colleagues, what we have here today is, in my opinion, a historic meeting, in the sense that this is a gathering where the Turkish lawyers will have direct access to the information of a particular state rather than the federal law of the United States. This, I think, is an exceptional and probably the first of its kind. Dear colleagues, beginning from the second part of 1920s, many Turkish lawyers started to be interested in foreign legal systems, because at that period, the young Turkish Republic, under the leadership of our founding father, first President Atatürk, codes such as the Civil Code of Switzerland to replace Islamic legal texts and case law. But their interests did not go any further than Western Europe. History tells us that there had been practically no direct contacts between Turkish lawyers and US lawyers until 1950s. I think one may say that US law was almost unknown to Turkish lawyers then. The first organized contacts between US and Turkish lawyers started in late 1950s. The Law School of Columbia University played the leading part in organizing and funding the programs under which Turkish lawyers could visit the United States and get acquainted with US system of law. It should be noted, however, that these contacts basically covered only the federal law of the United States. I think that this meeting of ours today is the first example where US and Turkish lawyers are coming together to discuss the peculiarities of the law of a particular state, namely Washington State's legal system. Thanking once again, especially Ms. Malat, who made this meeting possible. I leave the floor, or should I say the microphone, to the moderator. Thank you very much.
Thank you very much. We're very excited to be here to have this conversation. And we're very honored to be invited to this. This is also a historic event for us, as we've never participated in such a thing. And we're very interested to learn about the Turkish system and to share some ideas with all of you. And I will ask the presenters to proceed now, and I will introduce the first presenter, which will be Justice Deborah Stevens. She's a member of the Washington State Supreme Court since January of 2008. She's a native of Spokane, Washington, and she practiced law and taught as an adjunct professor at Gonzaga University School of Law prior to taking the bench. She's appeared as counsel on over 125 times in Washington State Supreme Court. She's deeply involved in efforts to advance justice and improve the legal system in Washington State and beyond. A leader in judicial and public education, she serves on the Washington Civic Learning Council, is a founding executive committee member of the National Courts and Science Institute, and a convener for Dividing the Waters. She has been a member and co-chair of the Board of Judicial Administration and co-chair of the COVID-19 Court Recovery Task Force. She's also active in the National and International Association of Women Judges and co-chairs in judicial independence. Internationally, she's worked with USAID to train foreign judges on issues of judicial independence and the rule of law. So without further ado, I will turn it over to Justice Stevens.
Thank you, Ms. Mallet, and thank you to Professor Aybay and our esteemed colleagues at the İstanbul Gedik University for putting together today's program. I'm going to begin by giving some landscape and overview of judicial independence and the systems in American courts that secure judicial independence. As was noted by Professor Aybay, we come from, myself and my colleague, Justice Madsen, as well as former Judge Rogoff, we come from the state court system. And so we'll be talking about some of the differences between state and federal courts in terms of maintaining fair and open courts. So if you would advance my slide, the next slide to show you is a picture of our courthouse. This is the Temple of Justice, where the Washington State Supreme Court sits. Though these days with the pandemic, we sit virtually. We have been hearing oral arguments through Zoom since last April, so just over a year. There are 9 justices of the Washington Supreme Court, and notably the current court, 7 of the 9 justices are women judges. and it is the most diverse court in terms of racial and ethnic background and gender of any state Supreme Court in the United States. Next slide, please, and actually advance that twice. So the idea of judicial independence, which is really core to our system, is that the judiciary must be separate from the other branches of government, namely the executive power, the executive branch, and the legislative power. In Turkey, of course, your president and your National Assembly. So to maintain judicial independence, one of the structures built into the Washington state system is that the judicial branch operates as an independent system of government. And we have state level courts, which include the Washington Supreme Court and the Court of Appeals, and then state judges who serve at the district, or what we call county level. And Judge Rogoff, former Judge Rogoff, was what we call a superior court judge in one of those courts, which are the general jurisdiction courts throughout the state. In addition to those state level courts, we have county limited jurisdiction courts. We call those district courts. And we have municipal courts in some of the cities in the state. And the jurisdiction of those courts is also limited. Next slide, please. I wanted to share this quote from early United States President and founder Thomas Jefferson, because it underscores and as the framers' intent that the institution of judicial independence was critical to the preservation of the American democracy, that it would be a check upon potential abuses of power by the other branches of government. And sometimes you'll hear the judicial branch referred to as the non-majoritarian or non-democratic branch of government. Of course, it is integral to the democratic structure of the United States, but it is non-majoritarian in the sense that the judicial branch adheres to the principles in the Constitution and the laws of the country without regard to popular opinion. And certainly the administration of justice would not be put up to a vote. Next slide, please. So judicial accountability and judicial independence go hand in hand, because we want the courts to be independent, but it's also critical that they be accountable to the rule of law as embraced in the Constitution and in really the structure of our system of democracy. And in order to ensure accountability, the judicial branch has instituted standards of ethics and transparency to help secure that value. And this is shown in the next slide, please. So as a brief overview, some of the structures for independence and accountability in our system of courts are the following. First, I'll talk a bit more about this. The methods of selecting judges is really part of ensuring their independence and their accountability. Second, as mentioned, rules or canons of judicial ethics and a process for enforcing those standards when they are breached through judicial conduct commissions. A third structure that ensures independence and accountability is the confidentiality of judicial processes. As a simple example, when the Supreme Court of Washington deliberates on a case, the deliberations of the 9 justices are not subject to public disclosure. So there can be open, full, rich debate and dialogue. But as a corollary to that is the fourth tenet, which is that the decisions of the court under our Constitution, all decisions of the Supreme Court are required to be in writing. And then also the institution of judicial review. So lower court decisions are subject to review by an appellate court. In our system, you may be familiar with cassation courts in some other European countries. But in the United States, judicial review is pure appellate review. So the appeals courts accept as verities any unchallenged findings of fact made in the lower court, either by the jury or the judge and review only on matters of law. And we can talk about that if there are any questions later in the program. And finally, I think often overlooked, but very critical to judicial independence and accountability is the tenure, secure tenure of judges and the security of judicial budgets, because we've all seen examples in countries throughout the globe that the surest way to attack an independent judiciary is for the legislature to cut off their funding. So budget security, of course, and the security of the tenure of judges is critical. Next slide, please. So I want to contrast how judges are selected in the federal system, the courts of the United States, versus in state systems. The courts of the United States comprise really one system. It is the federal court system. And most of the judges in that system are what we call Article 3 judges. It's set forth in Article 3 of the United States Constitution. They are appointed by the president upon approval of the Senate, and they have life tenure. So once appointed, they cannot be removed other than for misconduct. While that is most of the judges in the federal system, there are specialty courts, the bankruptcy courts, the tax courts, what we call the Court of Claims for federal contract matters. Those judges do not serve life tenure. They are appointed for a fixed term of years and serve, again, subject only to removal for misconduct during that term of years. Congress sets judicial salaries. And as I mentioned, the judges remain subject to a code of ethics. And as is also true in many state systems, judges can be impeached for any serious misconduct. So in a nutshell, that is the method of selection in the federal system. Next slide, please. When we look at the 50 states of the United States, we see a wide variety of judicial selection methods. And just to briefly overview those methods, some states have partisan elections. The judges run for office as representatives or members of a party, Republican or Democratic or Libertarian or Independent. That's less common, but still exists in several larger states, including the state of Texas. Many more courts have nonpartisan elections. This is what we do in Washington. Judges do stand for elected office, but they cannot belong to a political party. They do not run as representatives of a political party. They run nonpartisan. A few states have a legislative selection of judges, and they may thereafter be subject to a review, but that system is fairly uncommon. Other states have, and again, this is actually quite uncommon in the state system, the equivalent of a federal presidential appointment. They have a governor's appointment, a gubernatorial appointment, sometimes on consent. And in a couple of states, those judges so appointed do serve life tenure. And then a system that was becoming increasingly popular until just recent years was the so-called merit selection or Missouri plan, because the state of Missouri was one of the first to adopt this. And that's a system by which judges are initially appointed through a commission merit selection process, and then they stand unopposed for a yes or no vote. We call it a retention election every 8 or 10 years is most common. Could you show the next slide, please? Here is a map, and I realize the writing may be small. I don't know the type of screen you're all using, but it shows you the variety of methods of selection. Washington is the blue state up in the far, that's our west corner. We're the northwest, and those blue states are the nonpartisan open election states. Next slide, please. So to highlight Washington, since 1912, our races have been nonpartisan. I will say initially, Washington became a state in 1889. And we did initially have judges run for partisan office, but that went away in 1912. Importantly, we have an independent citizen salary commission that sets the salaries of all elected officials, not just judges. So they cannot be subject to legislative retaliation following unpopular decisions. Most judges at the trial court level serve 4-year terms, but appellate judges in the Supreme Court and the Court of Appeals serve 6-year terms. Some of our city judges, municipal judges, are still appointed, but all state judges are elected. And I just wanted to share a quote from one of the framers of the Washington Constitution. The method of selecting judges was hotly debated, and there were those who advocated for an appointment with a lifetime tenure rather than for popular election. But the view that won the day was this quote from a delegate who said, "No one's going to force upon the people better judges than they think they need." So we have always elected our judges in Washington. Next slide, please. I just want to, we're going to have a broader discussion about the independence and accountability of judges. And I want to emphasize that the method of selection doesn't necessarily ensure those values better in one method than another. I think there are pros and cons to the various methods. And I think that in all of the states, there's a desire to balance accountability with independence. And certainly the view in Washington was that being subject to the ballot would bring a greater awareness on the part of judges to how the law plays out in society and would improve accountability. I also think it's important to emphasize the difference that between independence and impartiality, though those things are related. I think securing the independence of the judiciary helps judges make impartial decisions. But that when we speak of impartiality, we're really talking about the ability of the judge to fairly decide the case in front of her on its merits without influence from any outside consideration. And I think the foundation to independence and accountability, whatever the method of judicial selection might be, is certainly trust in the rule of law. I think in our democracy, as in yours, the bare truth is that this system of government works because we are all willing to work for it and believe in it and trust in it. And trust in the rule of law is really that foundation. Next slide, please. Let me just briefly talk about our system of judicial ethics and the judicial conduct commissions across the states. There are 4 main canons of judicial conduct that are common across jurisdictions in the United States. Canon 1 is to avoid impropriety or the appearance of impropriety. Canon 2 is impartiality, competence, and diligence. Canon 3 is avoiding conflicts of interest, and so curtailing personal, business, extrajudicial affairs. And Canon 4 concerns avoiding politicking and keeping judges out of politics in their campaigning activities. Next slide, please. In our state, as in all states, there is a Judicial Conduct Commission. It's an independent commission whose members oversee complaints against judges based on violating the canons of ethics. These commissions act on when a complaint is made. They do not on their own go out looking for complaints. And they do not have any jurisdiction to address a judge's rulings on a case in front of that judge. It is simply for the judge's behavior and compliance with the canons of ethics. So unlike in some systems I'm aware of in Eastern European countries where the commission could examine a judge's decision, that cannot occur in the United States. Next slide, please. So some highlights of the Washington Judicial Conduct Commission. Importantly, the commission is, like the judicial branch itself, insulated structurally from outside influence. So the members come from the public as well as from the judiciary. They serve set terms. They are not made to report to any other branch of government. And I think that helps. You see in the slide the summary of how these are formed. I think that helps maintain the independence and integrity of the commission. Next slide, please. Equally important to trust and confidence in the judicial conduct commissions is the due process that is afforded to judges when they are subject to judicial discipline. And so, of course, they have notice of what the canons require. They are given notice of the complaints, an opportunity to defend themselves, to present evidence and meet the claims against them. And there are also levels of discipline from the least severe admonishment to a full censure that help regulate judicial ethics compliance without being unduly harsh on minor deviations from the code. I should mention that independent of the judicial ethics system, judges in Washington under the Constitution remain subject to impeachment as they do in the federal system. And I'm not aware in Washington that we've ever had a judge impeached through that process that would start in the legislature, but that certainly remains a possibility for serious misconduct. Next slide, please. The process is confidential, and I think that's important as well to public trust and confidence in the judicial system, and also to the ability of judges to participate in the system without fear of reprisal. It helps protect the reputation of the judge, especially when there are unsubstantiated allegations, and it also protects the integrity of the complaint process. Next slide, please. So other sources of, in addition to the selection methods we've reviewed and the judicial conduct commissions, let me just briefly mention some other safeguards, and I won't go into these too much. I referenced up front that tenure and budget security are important. Both Justice Madsen and I have served as the Chief Justice of Washington's Supreme Court, Justice Madsen for a very long term. And one of the responsibilities of the Chief Justice is really to oversee our engagement in the budget process, because the legislature does set the budget for the entire state. And so we have the obligation to advocate for our budget and work to adequately fund the courts. And I do think that in most American court systems, the struggle for sustainable, reliable, adequate funding is real. If people assume that that's not a concern or a risk to judicial independence in the United States, they would be wrong in assuming that. It's always a struggle, and particularly in times of budget crisis. Tenure is equally important. We serve 6-year terms, and during our 6-year term, we cannot be challenged based on any decision that the court issues during that time. I already mentioned the confidentiality of court deliberations, but the fourth point on this slide is what I want to turn to, which is the transparency of court processes and court hearings. Under our state constitution, Article 1, Section 10, we require that justice be administered openly and subject to public scrutiny. We also have a separate provision that requires the Supreme Court to state in writing the reasons for any decision. And I think that transparency, where people can watch a court proceeding, they can read a court decision, is really essential to maintaining trust and confidence in our legal process. And I think that is wholly consistent with the confidentiality of the deliberation processes, because people can see the evidence as it comes in, see the court hearing, but of course, for example, the jury deliberates in confidence in private, or the judges in a court such as an appellate court that has multiple judges sitting on a single case deliberates in confidence so that the debate can be open and uninhibited. And I think those two values of transparency of processes, but confidentiality of deliberations do go hand in hand. And so that's the end of my summary. This was just a brief overview, just underscoring that in all of the state courts, as well as in the federal courts in the United States, the twin aims of independence and accountability guide our work, but that there are many different methods of organizing the courts that can serve those values. So with that, I thank you for your time, and I know we will be taking questions later, so I will yield the floor back to Ms. Mallett to introduce our next speaker.
Thank you very much. Our next speaker is Justice Madsen. And Justice Madsen has a long list of accomplishments, but I will just name a few of them. Justice Madsen went to law school at she went to undergraduate at University of Washington, and she earned her JD from Gonzaga University School of Law. After completing law school, she worked as a public defender in King County and Snohomish County. Seattle is in King County. She developed the child abuse component of Seattle's family violence project. And she was then appointed to the Seattle Municipal Court bench, where she helped develop a domestic violence coordinating committee. She has always been committed to equal justice, and she continues to do so on the Supreme Court, where she has served since 1998. I think I got that wrong. I apologize. And she, as Justice Stevens said, she served as the Chief Justice of the Supreme Court. And among her many honors, Justice Madsen was the first recipient of the annual Mira Bradwell Award, which honors outstanding alumni of her University School of Law. And she's twice received the Washington Women Lawyers Vanguard Award. And I will now turn it over to Justice Madsen.
Thank you, Jill. I appreciate your attempt. I've been on the Supreme Court since 1992, and prior to that, I was appointed to the Seattle Municipal Court in 1988. So I've been a judge for more than 3/4 of my life, I think. So I would like to just mention at the end of Justice Stevens' remarks, she mentioned transparency and the ability to of the public to be able to see their justice system in action. When I joined the Supreme Court in 1992, a year later, we became the first court in the world, actually, to authorize television coverage of our Supreme Court hearings. And so people can tune in, even to this day, to watch gavel to gavel the hearings that are conducted in front of our Supreme Court. And I believe that it really has enhanced the trust and confidence of people in our state who can see what the issues are. They can hear the questions from the court, and then they can read the court's decision when we have decided the issues, which I think, again, makes the judicial branch the most trusted branch of the 3 branches of government in the United States. I've also noted that Justice Stevens talked about the selection of judges, and in our state, of course, we are elected, although initially, if there is a vacant seat, the governor can appoint to that vacant seat. Most of our judges are elected, however, including me. And that leads me to want to, I guess, introduce the reason that the court has taken such an interest in the community and the way that the community responds to the judicial system. We stand for election, and that means that we are accountable to the public. If the public is not satisfied after our term is expired, they can replace us, and frequently that does happen. So we need to be in contact with the public, and we need to be accountable to the public, but we need, of course, to be very cautious in how we are accountable to the public. I see Jill found the slides. That is a picture of me, of my children. I have 4 children and my husband, and that is my election sign strapped to my child's stroller. So when I was running for election, we had to go out to county fairs. We had to campaign vigorously because in our state, there are 7+ million voters that we need to reach. So we need to be in touch with our communities. Under our rules of judicial conduct, which Justice Stevens also mentioned and put in one of her slides, judges in our state are encouraged to be involved in issues of the administration of justice. Specifically, Canon 3.1 talks about judges being uniquely qualified to engage in the following: extrajudicial activities that concern the law, the legal system, and the administration of justice. If you could move to that slide, Jill. So our judicial conduct rules encourage our engagement, but they also put limitations on the engagement opportunities that courts can avail themselves of. When I first became a judge, there was great resistance on the part of many judges to become involved in issues facing our communities because of the fear that we might step over the line between having people advocate and having our own views being viewed as advocating. So it is a very fine line. My topic today is going to be the administrative role of our courts. Jill, if you could advance to my organization slide. That's the judicial conduct slide. We have a chart that shows the organization of the administrative organization of our courts, and I'm sure that will appear at some point on our screen. But courts differ across the country in how they administer their judicial systems. In some states, the Supreme Court has a very strong role in making the decisions about court rules, court procedures, court budgets, and indeed all of the resources that the courts rely on. In other states, such as Washington, where we live, our courts are considered decentralized court systems. And that means that there's a great deal of local control over the resources that the courts are given to operate under. There are what we call our local court rules, which may differ, although they cannot contradict the general rules, but many local courts adopt their own local rules. They also adopt their own local procedures, and they rely heavily on local funding for many of the programs that their courts offer, such as court probation programs and court advocacy programs. Many of those are funded at the local level. In our court, our Supreme Court does make court rules, and we do set procedures, but we have much less control over the operation of our courts than in a unified court system. And so what we need to do in order to ensure as much uniformity as possible in the quality of the justice that people get across our state, the Supreme Court has instituted a series of commissions and boards. And these boards and commissions work toward consensus around the issues that are facing the courts. So you can see in this chart that the Washington Supreme Court has instituted several commissions, and below those commissions, there are a number of committees. I would like just to address at this point the boards, the commissions that we have called boards in some instances, and to describe what their role is in the administration of justice. The first that you see under the Supreme Court auspices is the Board for Judicial Administration. The Board for Judicial Administration was an attempt early in the 1960s to try to bring courts together from every level to agree on such things as approaches to the legislature when court funding was at issue, for example. In 2001, our Board for Judicial Administration was reconstituted because it relies on a cooperation among all levels of court. Relationships had deteriorated somewhat between the levels of court, due sometimes, I think, to the attitudes emanating from our Supreme Court. But in 2001, we took another run at building a system for consensus building, and that is our current Board for Judicial Administration. That is chaired by our Chief Justice. So for 7 years, I chaired the Board for Judicial Administration, and then Justice Stevens most recently chaired the board as well. We try again to come to consensus so that we can speak with one voice. That is the mantra of our Board for Judicial Administration, speaking with one voice. It's important because we have, even though we are separate branches of government, a legislative, executive, and judicial, we are not hermetically sealed. We do interact with the other branches of government, including, of course, in the sense of our needs, our resource needs. We have to go to the legislature very frequently for funding for the various projects and procedures that we are trying to institute in our courts. So speaking with one voice becomes very important, and it's also very challenging in a decentralized system. The next board that is listed there is the Judicial Information System Committee. The courts, of course, were latecomers to technology. I think private industry has been automated for so long, but it took the courts quite a bit of time because, in part, of lack of funding, to finally build up our technology capacities. And the JISC, the Judicial Information System Committee, was an attempt in 2015 to, again, bring court levels together and come to consensus about data sharing, information sharing. I'm sure you understand, and it's true in your system as well, that you need to be able to communicate among all of your courts so that issues do not slide between the cracks, so to speak. The Judicial Information System Committee attempts to gain cooperation and build consensus and uniformity in our system, but as I said earlier, many of the local courts have local funding and they have chosen to build their own systems. So the JIS committee, which is a committee that I now chair, makes a valiant effort to make uniformity among our reporting systems, and so that every court in the state has access to the documents and the records of every other court in our state. The next is our Interpreter Commission. We were, I believe, the first state in the country to initiate an interpreter program. And the interpreter program is important because it requires professional certification for interpreter services. You can imagine in a country like the United States, where 1 in 7 people do not have English as a first language, it's so important that they understand the system that they become involved with. And so it became clear to us that we needed to professionalize interpreter services. And so now we have interpreter services that can be delivered only by certified interpreters or registered interpreters. And we cover, I believe, close to 50 languages in our ability to interpret, test, and certify interpreters. The next is our Minority and Justice Commission. The Minority and Justice Commission came as a result of a number of things that happened in our court system. I think, became much more open and willing to understand the racial disparity in our justice system. And it was quite late in my tenure as a judge, in fact, when we finally put our collective view about justice into practice by instituting the commission that is charged with maintaining a bias-free justice system. 1990 is the year that we instituted our Minority and Justice Commission. The commission has been incredibly active in trying to evaluate and understand where and if our justice system has gaps in the delivery of justice to communities of color. We have learned through a great deal of research that we have engaged in through the commission that some of our systems and our rules really are racially biased in their impact. And this commission is charged with finding those places where change needs to be made, and then educating our judges so that they understand where the bias points are in the system. And then we do education and training around those issues so that our judges can avoid the practices that lead to an unjust result based upon racial differences. The next is our Gender and Justice Commission. Our Gender and Justice Commission was also a latecomer. It was instituted in 1994, and this came about as a result of a study, an 18-month study across our state about practices in our courts that impacted gender in an unequal way. It began really by looking at domestic violence as it is perpetrated against women in our country and specifically in our state. But it has certainly taken on many, many more issues in the number of years that we have supported this commission. I was the chair of this commission for 20 years. And during that time, we explored the issues around gender and race and how gender and race really are compounding biases in our system. We have worked to develop new practices and procedures, court rules, and we have given advice to the legislature on ways in which we can better protect women and girls from domestic violence, along with other practical solutions to gender inequality in our courts, including in the area of family relations and making sure that we recognize the disparate impact that divorce has on women and children. And finally, the Commission on Children in Foster Care. This is our most recent addition in the way of commissions. And this commission was begun in order to address the practices that are engaged in through statute and practice in our foster care system. This involves children whose parents are unable or unwilling to care for their children in an appropriate way. And so they are taken into state care. And the role of the Commission on Children in Foster Care is to provide or ensure that children are provided with safe, permanent families in which their physical, emotional, intellectual, and social needs are met. This is a commission where there is a great deal of intersection between the Children's Administration, which is the executive branch of the government that provides protection for these children, and the court system, where these cases come before the court for determination of whether or not children will be removed from their families or whether their families will be given the necessary and appropriate treatment opportunities to improve their parenting skills and make them appropriate placements for their children. These commissions are all chaired by members of our Supreme Court. So you can imagine that in addition to all of our duties with respect to deciding cases, we also have the duty to administer justice through these commissions. And of course, you can see below that all of the other boards and committees that are active in our state and on which many of our justices either serve or have served in the past. We take seriously our responsibility not only to decide cases, but to make sure that as we decide those cases, our judges are as well informed as they can be about social science and about best practices that will take into account the trauma that many of our clients have suffered in their lives. And we want to make sure that going through our court system as a litigant or as a witness or in any other capacity does not re-traumatize people who have either been treated unfairly or who have experienced trauma in their lives. So that is a very strong commitment that our justice system has to the people who are using our court system. Thank you. I'll turn that back to Jill.
Thank you, Justice Madsen. And finally, we have retired Judge Rogoff. Roger Rogoff served as a county prosecuting attorney after he graduated from Emory University and went to the University of Washington School of Law, where he received his JD in 1993. After leaving the King County Prosecuting Attorney's Office, which is a county prosecuting office, he went and was in private practice briefly, and then he worked as a U.S. attorney. He was appointed to the King County Superior Court bench in 2013. He recently left the King County Superior Court bench, and he is now corporate counsel at Microsoft. I will now turn it over to retired Judge Roger Rogoff.
Thanks, Jill. First of all, I want to just again thank everyone for allowing me to be on this panel. I particularly am humbled and honored to be on a panel with Justice Stevens and Justice Madsen, two really iconic figures in the legal world in the state of Washington. I think if I could just brag a little bit about the two of them, Justice Stevens, before becoming a judge, which you've heard about, and before becoming a justice on the Supreme Court, was one of the most prolific and iconic civil litigators in the state of Washington, spent an incredible amount of time arguing cases in front of the Washington State Supreme Court on civil matters, and is now one of the representative on the Supreme Court from the eastern side of the state, which creates some geographic diversity for our court. Justice Madsen, in addition to what Jill described about her, I just want to make sure that folks understand the legal legacy that she provides in the state of Washington. And I want to do that by just pointing to the photograph that started out with her presentation. And you all should know that her husband, Don, who was in that photograph, the blonde fellow, was one of the, he retired recently, one of the most well-respected criminal defense attorneys in the state of Washington. And as a prosecutor from King County, I spent an incredible amount of time early on in my career trying cases against Don, laughing with him and arguing with him. Also, one of those girls in that photograph, Hillary Madsen, was recently elected to the Superior Court of the state of Washington and serves in King County Superior Court right now. So Justice Madsen, in addition to her incredible work on her own, has a legacy in the state of Washington that extends far beyond her. I was asked to talk a little bit today about trials, which is great because that is what I've done for the 27 years that I was a prosecutor, a defense attorney, and then a judge in Superior Court or in the trial courts. And it's a great way to talk about independence and accountability, which were the two themes that Justice Stevens and Justice Madsen began discussing here. Because trials, which are the way that Ordinary people and ordinary companies have the opportunity to have their disputes decided at the initial level of courts in the state of Washington, are designed to be transparent, independent, and accountable. They are accountable to the public because they are open courts. They are designed to be able to be seen by the public whenever and wherever they want to. If someone wants to come and see a trial in King County Superior Court, all they have to do is come to the courthouse and watch. And also now with COVID and the sort of beginning of using remote technology to help us be more transparent, most of our trials are also available via remote technology such as Zoom and other ways. There's also accountability through the jury system. And in the state of Washington, litigants have the right to a jury trial. So it is not a single judge making decisions about the results of their cases, but a jury of 12 people chosen from the community and are hopefully diverse and diverse in background, diverse in demographics enough to truly be a jury of the peers of the people who appear in court. I want to talk about a couple things regarding juries, and then I will be shorter, hopefully, than both of our justices, and then turn it over for questions on the rest of this panel. First of all, trials in the state of Washington are rare. 95% of cases that begin in the state of Washington resolve prior to trial. In other words, the process of getting to a trial is difficult enough and forces enough conversation that people are able to resolve their disputes and figure out a way to resolve their cases. This is done by a process called plea bargaining, which we can talk about if folks want to, which is controversial, but I think legally it has been deemed necessary to resolve particularly criminal cases as well as civil cases. Number two, I would say that trials are expensive, they're unwieldy, and they're complex. And I think they're designed that way. They're designed that way because by being unwieldy and complex, they are designed to protect the rights of those who are accused of crimes in the state of Washington. They're designed to protect the rights of litigants who have their cases heard in the trial courts in the state of Washington. And the procedures that are set up are designed so that jurors hear only the evidence that's necessary to make decisions about their cases, and not evidence that is prejudicial, unnecessary, or unfair. But they are unwieldy and expensive because here's what happens. We take a pool of potential jurors, 40 to 100 of them, bring them into a courtroom and whittle that number down to 12 or 13 jurors who will actually hear the cases. That process is overseen by lawyers, judges, and staff. The procedure then itself of the trial is designed to protect constitutional rights. People accused of crimes have the right to remain silent and don't have to say anything. They have the right to a lawyer whose job it is to defend them and to protect their constitutional rights. The process is designed to be procedurally fair, with opportunities for the lawyer for the accused in criminal cases to cross-examine all witnesses who testify against them. It is designed to be a fair trial substantively, so that there is review for decisions that are clearly wrong or where the evidence was clearly insufficient. There is a presumption of innocence for those accused of crimes. There is a burden, which is very high, for the state to prove that somebody has committed a crime, and that burden is beyond a reasonable doubt. And then, as I discussed earlier, there is transparency or open court so that folks can see how these trials happen. And in fact, we in the United States have spent the last 3 or 4 weeks, most of us, watching a trial in a state court in Minneapolis, where a police officer was accused and then convicted of committing murder against a young Black man in the city of Minneapolis. the transparency of that trial was such that folks were able to watch it all over the country at any time during the trial process. And were able to see exactly what the lawyers did, what the judges did, and how the witnesses answered questions, and what the closing and opening statements were like during the course of that trial. From my perspective, as someone who has done trials and has put on cases and tried to convince juries of the correctness of my particular case, when trials are done right, I believe that they are the best way to figure out the facts and apply them to the law and make decisions about how a case should be decided. I can't think of a better way to do it. I would also say that without a strong judge, without the different players in the court system doing their jobs correctly and earnestly and in the right way, that there can be incredible miscarriages of justice as well. There's opportunity for failure. There's opportunity for failure with unprepared defense attorneys, unprepared prosecutors, unethical prosecutors, weak judges, and lack of resources. And so I think that one of the things that all of us who have been trial court judges strive for in our courtrooms is to be strong enough to make sure that all of the pieces play their parts correctly and persuasively, do it in the right way, and ensure that all of the parties in the case are afforded the rights that they're entitled to. I would say that in our system, almost every criminal case is tried by a jury. There are situations where a judge might make a decision about a case when a defendant or an accused decides that that's the way they want to handle their case. But almost always cases are heard by the jury. And in my experience over 27 years, I am convinced that 12 jurors with differing backgrounds and differing experiences are always smarter than any one person, even the smartest judge in the state. They always get it right in one way or the other. And we can talk a little bit about that later. I would also tell you that over time in the United States, and certainly in the state of Washington, the art of trying a case is just that. It takes time and it takes experience to be able to tell a story to 12 people you don't know in a way that is persuasive and interesting, in a way that allows them to make a good decision. And it is something that folks have to learn to do. And the experience and the work that goes into that art is something that in the state of Washington, we have spent a lot of time trying to make sure we give to young lawyers and law students. Over the last 10 or 15 years, we have spent a lot of time and energy in our law schools, making sure that there are clinics available to law students so that they can learn how, not just to understand what the law is and how to apply the law, but also how to try a case and how to talk to people and how to make sure that the folks who come in to make decisions as jurors can understand the arguments that you're making, the law that applies, and the facts that you've provided them. And it is something that I've spent time teaching in law schools and am a very big advocate of continuing to do. And I think that the last thing I want to just talk about in trials is an issue that we could spend 4 weeks discussing here and elsewhere, and that is the work that trial judges, particularly in the state of Washington, are doing and continue to do to increase diversity in jurors and to work with the biases that we all have and that we come to cases with. There has been, as Justice Mattson just described, an incredible amount of work done to address bias in the jury system, address bias amongst lawyers and judges. And it is incredibly hard in a trial court situation where the biases that we all have, that everyone in society has, are brought into the courtroom and have to be addressed by judges and juries and the process as we try these cases. So that is what I wanted to say about trying cases in the state of Washington and Superior Court trials. And with that, I'll turn it over to Ms. Mallett.
Thank you very much. We have a number of questions, both from the audience. Professor Ibai had submitted some questions, and I had prepared some questions as well. So I'm going to first start with Professor Ibai's questions that I believe weren't addressed, and these can go to any of the panelists that wish to answer them. The first is there a minimum years of service requirement as an attorney at law to be a judge?
So yes and no. Interestingly enough, in our state constitution, there is no requirement of prior experience in order to sit on our highest court. The state Supreme Court, anyone can seek a position on that court, regardless of whether they just graduated from law school a week earlier, or if they have been practicing for 50 years. That's not true, though, of the Court of Appeals, which is the next court level below the Supreme Court. And in that regard, there must be 10 years, I believe, of experience before one can sit on the Court of Appeals. And then the Superior Court, I believe, is 5 years of experience. But so I don't believe there are any requirements of experience for the district or municipal courts, which really handle the bulk of the cases in our state. So it's really quite mixed.
The next question is, judges are elected for a period of time. Is re-election precluded? And if not, how often are judges re-elected?
I can answer that question. So, and it's interesting because periodically, including in this last legislative term, there are bills introduced to set term limits on the number of times judges might be able to run. But currently, there is no limit to the number of times a person could run for re-election as a judge. But we do have a mandatory retirement age, which was an amendment to our Constitution sometime in the 1950s, I believe. So for Superior Court and Supreme Court judges, they must retire at the end of the year in which they turn 75 years of age. Probably the most judges, I think if you look over the history of our state, most judges are reelected after having been elected, barring some very public crisis in their service. So it's really not incredibly common that a judge is tossed out midterm, but it sort of varies with the profile of the office, right? So at the Supreme Court, only 9 justices, very high profile. Most justices in recent years, at least I'd say in the past 20 years, those seats are often challenged, though, and certainly whenever there's an open seat, there are numerous people who initially seek that seat. But at least in my experience, and I'd be interested in former Judge Rogoff and Justice Madsen's perspective, I think at the trial court level, many of those seats, when there's a re-election, many judges run without opposition. And when that occurs, really just for logistics, their name isn't even on the early ballot, I guess. So that's kind of I think the system is somewhat self-regulating in that sense. And some of that, and there's many things to be said about that. We haven't really talked about the cost of elections and the distraction of elections. And in Washington, we've only had a couple of instances in which a ton of money was thrown at some judicial races. but that's becoming a game changer in a number of American elections, as you may be aware. And with a Supreme Court decision of several years ago in a case called Citizens United, the Supreme Court declared unconstitutional certain spending limits on campaigns on the theory that spending money on a political campaign is a form of free speech protected under the First Amendment. So the risk of a high dollar race is certainly being felt in judicial elections as well. While we haven't had a significant experience with that in Washington, we've had some experience, but certain states in this past year in 2020, North Carolina is a primary example. The Chief Justice of that state, they run partisan, so it was a Democrat versus Republican race, and all of the Democratic judges on the ballot, including the Chief Justice of the state, lost their election in multi-million-dollar judicial races. So that's a really important conversation for us to be having, but I'll just stop there.
What is the average cost of a judicial race, since you brought that up?
I don't know. I think average is going to be hard to see. Since I've been on the court, and actually just before I came on the court, was it 2016, Justice Madsen, when there was a lot of money thrown at 3 of the races. And I think including what we call independent expenditures, so money spent by interest groups, not directly by campaigns, like $6 million was spent on 2 races. In my own experience, I think, 40, 50,000, and that's a statewide race, but I've never had I was challenged once and my opponent was a disbarred attorney who drove a Zamboni machine at a hockey game. So it wasn't the kind of race that was going to bring a lot of money. But so I don't know that there's really an average. Some races, including at the Superior Court level, get very expensive.
The 2016 race was mine and 2 other justices who ran in 2016. And the race, we ended up having opponents because of 2 cases that we wrote as a court. And the 3 of us who were up for re-election had participated in at least one, if not both, of those cases. And there was a great deal of independent money that was spent to try to defeat us based on our decisions in those 2 cases. At the end of the day, though, the opponents were, their credentials were not strong. And I think that's why the incumbents succeeded, because the opponents were simply not particularly good quality candidates. But that kind of money could really have made the difference if the quality of the candidates that that were solicited to run against the incumbents had been of a greater a greater quality.
Ms. Malat, your microphone is unmuted. Is muted right now. Could you please unmute it?
How's that? Can you hear me? Okay, sorry about that. Technical difficulties. Can you hear me? Yes, okay. I'm working with 2 devices, so it's a very complicated system here. The next question is, the number of justices on the Supreme Court appears to be fixed. The legislative branch is empowered to increase the number of judges. How often is this power used by the legislature?
This is a very good question and a very timely question, because if you have followed the last presidential election, one of the issues which is now being explored by President Biden's administration is increasing the size of the United States Supreme Court, which is currently a court of 9. And I think most people recognize that when there is interest in increasing or decreasing the size of the court, there are political reasons for that. Increasing the size of the court gives a particular administration the opportunity to appoint new judges to balance out the number of judges that administration did not appoint. Decreasing the size of the court might be seen as a retaliatory measure against court action. In Washington, when the state was initially formed in 1889, there were 5. The court was created with 5, and that's what's established under our Constitution. And then the Constitution allows the legislature to increase the size. It was initially increased in 1907-ish, I think, to 7. Really during an era in American politics when there was an interest in greater populism, representation, with the thought being that a bigger court would have would be more in touch with the populace. And then it was increased very shortly thereafter, just a couple of years later, to 9, and at that time then made nonpartisan. We've had, since I've been on the court, in response to one of the decisions that Justice Madsen referenced, a case in which I authored the opinion, but we declared the system of funding public education in Washington to be unconstitutional under a specific provision of our Constitution, making provision for education the paramount duty of the state. And a bill was introduced the year after that in language that mimicked language in the opinion, saying that, the legislature could no longer afford to pay for 9 justices. That was just too expensive. So they were going to reduce the court back to its constitutional minimum of 5, and they were going to make the justices stand on the steps of the Temple of Justice at high noon and draw straws to see who would draw the short straw and have to be removed from office. And clearly that was more rhetoric than substance. So that power, I'm unaware. I think it actually has happened, but I couldn't tell you where, of a state that has reduced the size of its court for administrative reasons. I believe that maybe did happen in one state that went to 9 and then quickly back to 7. But I will say that Washington's court of 9 distinguishes us somewhat. Most state courts, even very large populous states, have a court of 7. And some of the less populated states have courts of 5, but we've had 9 since the early part of the 20th century. Anything Justice Madsen or Judge Rogoff would like to add to that?
I would just say for trial courts, in King County Superior Court, we currently have 53 judges. The legislature recently made a decision to increase that by 1, but that is all based on workload and the amount of cases that each judge is carrying. And there's actually a mathematical formula that helps the legislature make those decisions.
I would just say that there have been, over the years that I've sat on the court, at least 3 genuine attempts to reduce the size of our court. And they have all failed, but they all have stemmed from political reasons. But I point that out only to say that that there's always tension among the 3 branches. When the court rules that a statute or some law that's been passed is unconstitutional, there are legislators who become quite incensed. And sometimes even the governor might become incensed at the temerity of the court to say that something they have adopted is unconstitutional. So there's always going to be tension, and that's just an example of how the tensions can play out.
The next question is, when a vacancy occurs in the office of judge, the governor appears to have the power to appoint a judge to fill the vacancy to serve until a new judge is elected. Does the governor take the decision individually or seek the approval of the state legislature?
I'll go ahead and jump in on this. I was initially appointed to the court on January 1st of 2008. And the process is really the governor's. So it is not directly parallel to the federal process where the president makes an appointment, but the Senate has to confirm. It's not like that. It's strictly the governor's appointment. But as I always viewed it, that means that the judge who will then immediately stand for election in the very next general election has one vote, which is the governor's. You still have to run for office. I was fortunate that the year I was appointed was also the year that the seat, position 7 on our court, was up for election. So I had to run immediately, but that was to retain for a 6-year term. Others who are appointed, including a couple of our colleagues on the Supreme Court, had to immediately run to retain the seat, but only for the remainder of the term. So maybe a year and a half or 2 years, and then had to run again entirely. I will say that our governor, Governor Inslee, just like the previous 2 governors for certain, and I think it goes back farther than that, has a vetting process and is very interested in hearing from the legal community and the community at large about candidates for judge. And so there is a requirement under this governor's process, as the previous governor who appointed me, that the candidates be evaluated for their qualifications by different bars, different specialty and minority bar associations. There used to be a recommendation committee through the state, the integrated state bar system. But I think that those of us who have been appointed were evaluated by, I know in my instance, it was at least 7 committees of minority and specialty bars that will rate a judge exceptionally qualified, qualified or unqualified. So the governor definitely wants a thorough vetting process. And speaking just for myself, I can tell you that the application, the questionnaire that I filled out to be screened before vetting took me about 50 hours to complete, because they want to know all the cases you've tried and names of opposing counsel. And, it's a tremendous amount of information, which I think helps serve that screening process before an appointment is made.
Okay, I'm going to take some questions from the audience. We have about 20 more minutes and then we're going to take a break. The first question is, this is to all the speakers. When we look at the Washington Supreme Court justices, we realize that the number of women judges constitute the majority. Do you still think that there is room for more development in this regard? Do you believe that the number-based positive discrimination is enough in this respect? This is an important point regarding gender equality and women empowerment. How do you evaluate the U.S. experience in the empowerment of women judges?
Well, I was elected, as I mentioned earlier, in 1992, and I was only the 3rd woman to ever sit on our state Supreme Court. So it was essentially 100 years with no women, and then I became the 3rd woman. When I joined the court, I did so because I believed that there was gender inequality in our profession in the state of Washington. And I decided that we needed a woman's voice at the table where decisions were going to be made about the practice of law in Washington state. And so that's why I sought election. I was the first woman ever to actually run for the state Supreme Court and not be appointed. I was, we called it at that time the Year of the Woman, because many, many women came out to run for public office. It was the same year that we had 9 women out of 10 statewide offices, 9 women won election that year. So we really turned out in great numbers because there had been so little attention paid to gender equity up until that time. my goal in joining the court was not so much to decide the cases, to be very honest. It was to change the culture of the legal profession in our state. We've made a lot of progress, I believe. You can see 7 of our 9 justices now are women. But what's become much more obvious to me in the last many years is that gender is not the only place where our equality breaks down, and that is along racial and ethnic lines, where those voices also need to be heard at our table. And I think we've done really very well in the last, say, 5 to 6 years of adding minority voices to our court. Justice Stevens mentioned that we have one of the, or I think actually the most diverse Supreme Court in the country. We have an African-American member, we have a Native American member, we have a Latinx member, we have a Asian member of our court, and we have a variety of religious backgrounds, including Jewish members, Catholic members of the court. So we have really achieved, I think, a great balance around the table of the Washington Supreme Court. As far as the profession, there's still a great deal of work to be done in the everyday courtrooms across our state. That's why in the last 20 years, we've paid so much attention to judicial education. Our trial courts are under-resourced. They don't have the opportunities for education that we would like them to have. And I think that there's still a great deal of work to be done, not only with our judges and court staff. We know that there are bias issues in our trial courts, but also with the people who are serving as our jurors. So there's a great deal of work still to be done around gender and race and culture. But we have made great strides, I believe, and continue to have those issues as a very central focus for the work that we're doing.
I would just piggyback on that and add that this is one of the situations where I think that leadership in the state is pulling the rest of us in a very positive direction. In the trial court in King County, there are 53 judges, and the majority of those are now women, with some significant diversity on that bench. I would say, though, that as a judge, when you are sitting during trials and during hearings, you see the continued unfairness that women and minority lawyers face as they participate in this profession. You see partners who are mostly male in the large law firms take credit and oral argument at hearings where it's clear that the non-partner, sometimes women, sometimes minorities, are the ones who wrote the briefs and did the work. And it is something that judicial officers across the state need to be incredibly active with to ensure that we root out that prejudice and that bias.
Can I add just something to this too, because I really completely agree with Judge Rogoff and Justice Madsen. I also just want to comment that I was in law school when Justice Madsen, at a very young age, was first elected to the Supreme Court. And the role model that she has provided to so many women in the profession who could see a young woman, a mother of 4, someone who was, strong and embraced her role as both a judge and a mother, that was huge for all of us. And I started law school with a 6-week-old baby. So I guess to me in particular, it was really inspiring to see that balance. But that brings me to the thing I want to stress is I think that addressing the marginalization of women and minorities in the community requires us to look at the structure of how we do business, how we practice law, and how the courts run. I have heard, I was in academia too, and famously a dean who said, we don't have a woman problem, we have a mommy problem. Where are your priorities? That sort of thing. And I think that this notion that we're going to maintain this patriarchal system of law practice or law and just bring a few women and minorities in is just not a sustainable notion. So I think there's really, there needs to be a constant effort to reimagine how the institutions operate, to really bring in and include the experience and the voices of all. And it makes obviously for a better justice system, right? It's a much more authentic, real justice system that's better meeting the needs of everyone. But I think we know it's as if you take a couple steps forward and one step back. It really requires constant work and vigilance.
The next question is, how does the procedure continue after the investigation of commission regarding judicial misconduct? Who makes the decision on disciplinary punishment? If a criminal charge is to be pressed, does the commission send the file to the prosecutor?
I'll jump in. It's hard because if we were sitting on a platform, a podium together, we'd look and say, "Oh, you take that one." I'm sorry, I'll jump in again. And Justice Madsen has been on the Supreme Court a long time and can speak to there are cases that will come to the Supreme Court for review. In a nutshell, let me address the last piece first. There are instances, and there's a fairly high-profile case in Washington right now of a judge who did not run for re-election and so is no longer on the bench, but who has been facing for the last 18 months criminal sexual assault charges. And typically, the Conduct Commission will hold in abeyance discipline premised on that same conduct while the criminal process plays out, because of course the presumption of innocence until proven guilty in the criminal system, and there is an interest now, partly in light of that direct experience, in examining what the options are for temporarily having someone leave their office and have someone cover that office. And I think a lot of the commissions, judicial conduct commissions across the country, are looking at what the options are for that. But typically the discipline is imposed by the commission, and then this is really high concept, but there are instances in which that might be that could be subject to review by the Supreme Court. But it typically it's the decision of the commission whether to admonish or reprimand or censure the judge. Anything you'd want to add to that, Justice Madsen?
Yes, I would just say that if the commission decides that there ought to be a suspension or a removal of a judge, then it does have to be reviewed by the Supreme Court, the Washington Supreme Court, which became problematic when one of our own members was being investigated and ultimately was sanctioned by the commission. And our statute, which sets out the procedure for how these hearings are conducted, sets out specifically that if one of the members of the Supreme Court is the subject of the investigation and the discipline, then the court shall impanel a court of comprised of Court of Appeals judges who then sit as the Supreme Court and make the decision about the sanctions. And that did happen in our colleague's case. A group of Court of Appeals judges did uphold a sanction against one of our own members. He was ultimately, another term later, the citizens did not re-elect him. And so that he was no longer able to sit as a judge, but it does require the Supreme Court to authorize the suspension or removal of a judge.
The only thing I would add is just with regard to the notion of a criminal prosecution or criminal investigation. And I just want to make clear that that would be a completely separate, completely unrelated process that that judge would go through. And although the police and the investigators on the criminal case might use some of the information from any kind of judicial investigation, the two processes are completely separate and have nothing to do with one another.
Okay, and I think we have time for one more question. Does the election of judges prevent their decisions from being objective? When the time comes to decide, do you feel a pressure between the will of the people and true justice? I realize it's a big question for 6 minutes.
It is a big question, and it has a variety of answers, I think. So as a personal matter, of course, I've run for re-election, I believe, 5 times. And almost always, I've had opposition in my re-elections, and oftentimes it was because of a case that I wrote. And what I realized, I think, pretty early was that you really cannot please everyone. And so what you need to do is to put out of your mind what might be popular, because you will never know what is really going to be popular. And you make the decision based upon the law and the precedent that has been set by cases that came before. And you do the best that you can under the circumstances to deliver an unbiased and impartial decision in every single case. Now, that's, of course, aspirational, and I think most of us believe that we can do that. However, there have been some studies that study the decision-making in criminal cases in particular in the year before and during the election of judges. And there is some evidence that suggests that judges do decide cases differently during the year running up to their elections. And they tend to be tougher on crime during those years in terms of how their decisions come out. Now, again, I don't know the validity of such studies, but I can see how it would make some sense. There is pressure. No system of selection of judges is perfect. I think in an appointment system that there's still removal, that judges are conscious of how their decisions will be, what reaction there will be to their decisions by the authorities that can remove them. So it's really, to me, and there might be other answers from the other panelists, but to me, it's really a matter of personal integrity and personal ethics, that you put the considerations of yourself aside, and you make the best decision you can under the law without regard to whether it's going to help or hurt you in your election.
I'll jump in. I think it'd be great if we all just weigh in briefly on this one. I'd love to hear from former Judge Rogoff too, because I feel like sometimes the pressures are greater in the trial courts, because of just that greater community contact. But I do think, especially, so I have only ever been an appellate judge. I was never a trial judge. I was briefly on the Court of Appeals for less than 1 year, and then I've been on the Supreme Court since 2008. And so our jurisdiction is a discretionary jurisdiction. We take only the most important cases, and our docket becomes more politicized as it's a politically charged term, but people talk about weaponizing the courts, right? Taking high-profile social issues and turning them into cases and, test cases, that sort of thing. We can't hide from those because that's the nature of our jurisdiction. So most of what I have seen is you're going to make controversial decisions in very high-profile cases. And at the end of 6 years, you've probably impressed and annoyed everybody in the state. And so I really think the kind of person who's drawn to doing the work just sees that comes with the territory. And So I think as an institutional point of pressure, it might be less so on Supreme Court justices than on trial courts. I think the study that I'm familiar with that Justice Madsen was referring to, which actually studied King County judges, looked at their sentencing decisions because judges have great discretion within a range of the length of sentence, prison term, or other aspects of the sentence to be imposed, and did find that, you know, across the period studied, that you could see a little uptick, you know, that because it's generally regarded as, or at least had been up until that point. I'd be interested to see what the research would show now in the last couple of years, especially with just the increased focus on how America over criminalizes and over punishes poverty behavior and how racially biased it is. The trend may be different, but I think there's some greater direct pressure in those discretionary decisions, which is why I was interested to hear Judge Rogoff's perspective on that, because I have to say, from a Supreme Court's perspective, you know, we annoy everybody after 6 years, and we make everybody happy after 6 years, and so it's just kind of a non-issue, I think, at the Supreme Court, or less of an issue, at least in my experience.
Well, thank you. From a trial court perspective, one of the nice things about our decisions is that typically they're not written and they're not published. So that helps to sort of ameliorate some of the pressures that we might feel from any one decision. But I believe the science on the decision making from that study. There is a pressure there. I think it exists, and it makes decision making more difficult. I'll also tell you that there is a study out there that says that trial court judges sentence more harshly late in the day, when the day is almost over and they want to get through, or just before lunch when they're hungry and they want to get out to eat. So I think, you know, not to make light of it, but there are a lot of pressures that affect you as a court, and some of them are clear and you can address them head on, and some of them you probably don't even realize, and some of them have to do with your own biases and how you see the world. I think a lot of the Superior Court judges try to address those pressures by keeping track of what they do. And when I was a Superior Court judge, I did that with my sentences. I kept track of every sentence, grouped them by type of sentence, kept notes on the reason I made the decisions, and kept notes on the demographics and the background of all the people that I had sentenced, in an effort to try to be mindful of all of the biases that are going to impact me, including, you know, the fear of not being reelected, including the unconscious biases that we all have with regard to race and background and so forth. So I don't think you can run away from the fact that that pressure exists. I think judges have become very mindful of it and try very hard to find ways to address it in their decision making.
Thank you. I believe that concludes our portion of this program. I just want to really thank Justice Madsen, Justice Stevens, and former Judge Rogoff. This has been really a learning experience for me and really very inspiring. So thank you very much. And also, of course, thank you to our Turkish hosts. I look forward to the second part of this program, and I'm excited to learn about the Turkish system.
Thank you very much, Ms. Mallet. Now we are going to give a little short break for 5 minutes. Then we will start our conference back around 10, let's say 53. And now Hukuk Alemi is going to make a little announcement in Turkish. Thank you very much.
Arkadaşlar, şimdi 5 dakikalık bir aramız olacak. Ancak araya gitmeden önce kısa bir duyuru yapmak istiyorum. Temiz Eğitim Kurumları'nın 10 ayrı ders için hazırlamış olduğu özet ders notları çekilişine katılmak için Hukuk Alemi Instagram hesabımızı ziyaret edebilirsiniz. Bu eşsiz set şu anda hiçbir yerde satılmamaktadır. Parayla satın alamayacağınız kadar değerli olan bu seti kazanabilmek için çekilişimize katılabilirsiniz. Çekiliş linkini arkadaşımız birazdan yorumlar kısmına bırakacak. Bu arada ikinci oturumun başında yorumlar kısmına arkadaşlarımız bir başka çekiliş linki daha bırakacak. Bu link yayın sonunda yapacağımız diğer çekilişlerimize katılabilmek için doldurmanız gereken form linkidir. Şimdi bir 5 dakikalık bir ara veriyoruz. Ardından kaldığımız yerden devam edeceğiz. Bir dakika abi, şimdi ayarlıyorum.
Honorable guests, distinguished professors, dear participants, we are now proceeding with the second part of our conference, and this session will be moderated by Dr. Ural Akuzum, Assistant Professor at İstanbul Gedik University's Administrative Law Department, and Attorney Çağla Arslan Bozkuş. Our honorable guests, the Judge of 29th Criminal Court of the Istanbul Anatolian Side Courthouse, Judge Mahmut Erdemli, and the Rapporteur Judge of the Turkish Constitutional Court, and Coordinator of the Constitutional Research Center, Dr. Mücahit Aydın, will deliver their speeches in relation to the judicial system in Turkey. Now, I would like to yield the floor to Dr. Ural Akuzum.
Hello, distinguished guests, professors, and dear participants. Once again, I would like to welcome you all to the conference on judicial systems in the United States and Turkey. As we had a first session focusing on the judicial system in the United States, in this session, we aim to focus on the judicial system in Turkey from a similar framework to provide a comparative perspective. Today in our session, we have our distinguished judges, Judge Mahmut Erdemli and the Rapporteur Judge, Dr. Mücahit Erdemli. I would like to emphasize that it is such a great opportunity to be able to evaluate this topic with the judiciary members. In this session, we will particularly focusing on the judicial organization in Turkey, the judicial independence, and the right to fair trial. These are extremely important topics concerning the Turkish judicial system. Discussing the questions arising from these concepts is very crucial to tackle the structural problems in the judicial system. Now, I would like to yield the floor to our first speaker, Judge Mahmut Erdemli, to enlighten us regarding the judicial organization and judicial independence in Turkey.
Okay, I'm preparing to see my PowerPoint presentation. Try. I wonder if my PowerPoint presentation is seen by the participants and audience. Can you confirm that?
Yes, Your Honor, we can see that.
Thank you. I would like to thank the organizer, University, Gedik University, and also the colleagues from the United States who dedicated their time and effort to prepare their presentations. Also, they spare time during the working time. I also thank my colleague from the Constitutional Court for participating in the event. I'm a criminal court judge in the first instance for about 25 years. The last 20 years passed with the criminal court in the first instance. So I will be more competent to answer the questions in the end of the presentations when it is related to criminal justice and it is related to criminal courts. Yeah, when we look at the Constitution, it's not very different from any democratic country in the European Union, which stipulates that the courts are independent and impartial, and the courts do not receive any recommendation from any authority regarding their judicial duties. Legislative and executive organs comply with court decisions without delay or alteration, and the judges may not be forced to retire or be removed. And establishment and functioning of the courts are regulated by the law. So we will We will see the organization first, very briefly, and after that I will try to make an attempt which Department of Judiciary as a whole creates what kind of challenges to the independence in the judiciary. I will start with Judicial Council, which has an extensive power to appoint judges, to admit judges into profession, to transfer them, to supervise, to suspend and promote, also carry out disciplinary investigation by using its inspection board. So the Judicial Council is empowered not only appoint the local court judges, but it is also empowered to appoint Supreme Court and Council of State judges. By the way, Council of State is the equivalent of Supreme Court, which review the cases coming from administrative and regional administrative courts, while the Supreme Court reviews the cases coming from the judicial or the courts from the courts with ordinary jurisdiction. So the Supreme Court it reviews, upholds, or overturns verdicts of local and regional courts of ordinary jurisdiction. It also conducts trials when senior judges and when the judges of Supreme Court are charged with criminal offenses. In normal circumstances, Supreme Court makes the final judgment for ordinary citizens, but when it acts as a first instance court when trying the individuals that I said, including its own judges, it is appealable to the plenary board, which consists of judges from each chambers of the Supreme Court. As far as I remember, the Supreme Court has now about the criminal section of Supreme Court. It has now about 22 chambers. We have also regional courts. These courts have been established in the last few years. In the past, we had the local courts and the Supreme Courts. Regional courts are right now between the local courts and the Supreme Courts. The regional courts also reviews the decisions made by the local criminal and civil courts, just like the Supreme Court. But its decisions also are appealable before the Supreme Court if the subject matter of the case exceeds the certain level of importance. As an example, if the local court, the criminal local court, punishes the suspect not less than 5 years in prison, sorry, not more than 5 years in prison, then the regional court is empowered to make the final decision with no availability to go to Supreme Court. So the local courts, we have two levels of local courts. One, criminal courts of general jurisdiction and the criminal assize courts. And also we have Court of Peace judgeships. And these courts are located in every province. In Turkey, we have 81 provinces, and also in almost any district. Some of the district, the Turkish government closed the courts in some of the big districts because there were not a lot of cases flowing into these districts, so that the government can use the courts and the judges more effectively. In the local courts level, when a criminal court of general jurisdiction makes a judgment, it normally doesn't go to the criminal assize court, which is actually higher than the general jurisdiction court. But some of the decisions by criminal court of criminal court of general jurisdiction goes to assize court, such as arrest decisions and the decisions that in which the punishment has been delayed. It's a kind of suspension of the punishment. So this means that the assize court only reviews the decisions related to arrest and the decisions for unimportant punishments. So before evaluating the independence of the Turkish judiciary in each level that I have mentioned, we need to know the requirements of independence. What does it mean to be independent, and under what conditions the Turkish judiciary can be considered independent? Turkey is a party to both human rights systems, namely European human rights system and the United Nations human rights mechanisms. And the Turkish constitution requires that human rights conventions take priority in case of conflict between the national law and the human rights law. Because we need to take into account the human rights conventions and the case law of the supervisory bodies of these conventions, I will elaborate a little bit what is required to be independent. In one of the judgments, European Human Rights Court, in one of the judgments, stated that for a court to be independent, the manner of appointment of its members and the duration of their term of office, the existence of guarantees against outside pressures, and the question whether the body represents an appearance of independence should be taken into account. This means that when the necessities starts from the beginning, when the judges are appointed or admitted into profession, the body admitting a judge should be independent, and also judges should be until the retirement, if there is no exceptional circumstances, should be able to stay in the same office, same location, if there is no will to change the location. Also, outside pressures, whether it is coming from the executive body or from other authorities, should be prevented, and the judges should be protected. And the body, any judicial body should appear independent for outsiders. Also, informal European Charter makes a specific comment with regard to a judicial body who is empowered to make the decision of recruitment, about the recruitment, career process, and dismissal of judges. Such a judicial body must be chosen by the actors, by a group of people half of whose are the peers of judges. I mean, half of those choosing such a judicial body must compose of judges themselves. So there will be a wide representation of judges in such a body. This is valid for the Judicial Council in Turkey. Finally, the Human Rights Committee made a comment that is similar to the case of the Human Rights Court. So it paid attention the procedure and qualifications for the appointment of judges and the security of their tenure, and the conditions for promotion, transfer, suspension, and cessation. they should be clearly and objectively regulated so that there is no outside pressure plays a role in such decisions. Also, we have a national law, which is a law on political parties that prohibits judges to be a member of a political party. This means that the Turkey and also European system is very different from the United States system. Judges may not be affiliated with the political parties in any circumstances. How is the Judicial Council composed of this? I will be my focus will be on Judicial Council because it is such an important body which is empowered to appoint judges, to prosecute, to disciplinary investigate them, to suspend them, to relocate them. So that there is every authority that this council has. Before 2017, we have a comparably better and more democratic and more independent judicial body, which consisted of 22 members, 10 of whom were selected by local court judges themselves, and 5 selected by the Supreme Court and the Council of State members, and 4 by the President of the Republic, and 1 by the Justice Academy. So apart from the 4 of them chosen by the President of the Republic, the others are all independent people or institutions, and this means is at least seemingly this body was more independent than what we have at the moment. Currently, after 2017, of 13, 6 of the members of Judicial Council are chosen directly by the President of Republic. How does it happen? The minister, Justice Minister, and its deputy, they are ex officio members of the council, and the other 4, they are chosen from amongst local court judges by the President of Republic. 7 are chosen by the Parliament from amongst Supreme Court, the Council of State, academicians, lawyers, and the Council's President is the Justice Minister. So in this current system, none of the members of the Judicial Council is chosen by higher court judges. There are some measures that aim at independence of the Judicial Council. One of them is that it operates with 2 chambers and 1 plenary session, an inspection board which disciplinary investigate judges, and which also prepare papers for judges, which are important for their advancement in the career, their promotion. This inspection board is subordinated to the Judicial Council, not to the Ministry, and its members are chosen by the plenary session. And also, the important part is that the Judicial Council has its own secretariat and its budget. And the Justice Minister, President of the Judicial Council, can only attend plenary sessions when it is not related to disciplinary issues on judges. And any decision by the chambers, whether it is disciplinary nature or administrative nature, is objectionable before the plenary session of the Judicial Council. So any judge has the second chance to be protected in the plenary board. The important part of the composition of the Judicial Council is the selection process in the Parliament. As we saw earlier, that the 7 of 13 members of the Judicial Council is selected by the Parliament. How does it happen? There are two committees in the parliament, which is Justice Committee and the Constitutional Committee. These committees, this joint committee, nominates 3 judges for each membership. So this means that they will nominate 21 judges for the Grand National Assembly to elect them. And so we have 2 stages. One is joint committee stages, nomination, and the Grand National Assembly election stage. And in both stages, we have the same rules. The first voting requires 2/3 majority, and if failed, 3/5 majority is required. And if failed again, 2 members getting the highest number is chosen by lot, by chance. So what are the problems with this parliamentary selection of Judicial Council members? There is no absolute requirement of qualified majority. Yeah, when you read the Article 159 of the Turkish Constitution, if you don't read it don't read it carefully, you may think that it is selected by the qualified majority. So you may think that there is a say by the minority party members. However, in the end of the process, if the judges are not selected by the qualified majority, then there will be a simple majority, which the government has in the parliament. This means that in the end, the government will be able to choose all the members, all the 7 members, according to its wishes. And regarding the other members, yeah, I mean, I forget to explain what judges are they who are selected by the parliament. They are the judges from higher courts, academic institutions, and lawyers. And these are not chosen by their peers. These are chosen by the parliament amongst the applicants. I earlier stated that the system before 2017, it required that partly Supreme Court, Council of State, they made their own nomination, and from amongst them, the members were chosen. Yeah, when also we consider the 2 official members are also part of the governing party, we can see no traces from the opposition parties, and there is no common will of the institutions, especially judicial institutions, higher judicial courts, higher judicial bodies. After seeing all the particularities of selection and composition issue of the Judicial Council, what we have at hand is that there was, I first want to explain, tell a little bit about what we experienced during the times when we were able to select the judicial members partly. I mentioned that some 10 of 22 members before 2017 were chosen by local court judges. What happened is important to understand the mentality of the executive body and also the judges, whether they are Supreme Court judges or local court judges. And it's important to understand what we have as a problem with regard to the independence of judiciary. During the selection process in 2014, there was a creation of Judicial Unity Platform. Then after this was to be transformed into a judicial association. This platform, the creation of this platform coincided with the election process into the Judicial Council. And this platform was helped a lot by the Ministry of Justice, and there were a lot of logistical help. While the other parties entering into election lacked such a help, and they used their own force, their own sources. They used their own money. They visited the judges, etc. They visited the other cities. There were allocation of resources by the government to this judicial association. And what happened also, many Ministry of Justice bureaucrats visited the judges before the election and requested to vote for the list of the candidates which was prepared by the executive body, Ministry of Justice. And apart from this, the government also promised an increase in the salary of judges that would happen after the election. And when all that is combined, the government succeeded to have its list to be chosen. Most of them, at least, not all of them, but most of the candidates in the Ministry of Justice list were chosen to be Judicial Council members. So one of the reports prepared by the 2020 European Union Commission states as follows. There were reports that membership of an association that was perceived to be opposing the government was seen as hindering the prospect of career advancement. Turkey's biggest association, the Association of Judicial Unity, which reached around 9,300 members, was perceived as being close to the government. Newly recruited judges and prosecutors are handed a membership application to the Association for Judicial Unity automatically upon recruitment. So after the composition of Judicial Council in this way, there were a lot of involuntary relocations of judges and unfounded disciplinary proceedings, which means the proceedings which did not have legal reasoning. I will give certain examples that I collected mainly from the reports of non-governmental organizations. In 2017 and 2018, 25th Assize Court Judge in Istanbul and 37th Assize Court Judge in Istanbul one of them is suspended and the other was demoted. The others were demoted after releasing journalists and lawyers in a case. And Diyarbakır 8th Assize Court Judge was demoted after releasing a Kurdish parliamentarian. I personally know two judges who made an application to the Constitutional Court to have Article 299 to be annulled. The article envisaged the punishment for the defamation of the president, and it required a specific and harsher punishment compared to the defamation of the ordinary citizens. These two judges relied on the case law of the European Court of Human Rights, which stated that envisaging such a punishment harsher punishment for defamation of president compared to defamation of ordinary citizens is the violation of free speech rights. What happened was both judges were relocated and were sent to very far away cities that they were working compared to the city where they work. And one of the things that Judicial Union had was suspended after reminding the rights of a prisoner who is charged with terrorism. And about 3 years ago, I learned that about 17 out of less than 100 members of Judicial Union were relocated and subject to disciplinary investigation. Some of them was not shown any legal reasoning. They were just said that you did this act, and tell me your defense. And there was no judicial reasoning, legal reasoning, which disciplinary offense was committed. It is not known. Yeah, there are some other examples. In 2020, disciplinary investigation is 3 judges of 30th Istanbul Heavy Penal Court who acquitted the defendants in the Gezi Park trial. Yeah, this examination was about the Judicial Council. We also have issues with the local courts. The courts also were criticized by by the way by which it functions, and by their acts, which put their independence, the independent appearance in jeopardy. For example, 2 journalists, Erdem Gül and Can Dündar, the Constitutional Court find violation of the right to liberty and free speech with regard to their detention during a trial. And after this finding violation, the Prime Minister declared that he will not abide by the court decision. Afterhand, I know that these journalists were released. There was not a big loss of right to liberty, but in the other instances we had the problems. For example, another journalist, Mehmet Altan, he was arrested in 2016, and he applied before the Constitutional Court that found violation of right to liberty and free speech in 2018. So he was in custody for 2 years. And 26th and 27th assize courts in Istanbul rejected to free him due to lack of recent judgment of the Constitutional Court, whose webpage actually contained it. And in 2020, Constitutional Court found another violation for the same journalists, violation of liberty rights. And during those applications, the then Justice Minister said that the Constitutional Court exceeded its boundaries. And afterhand, the local court rejected the application for releasing the 2 journalists. And finally, one opposition party deputy, he was being tried because of providing information to a newspaper, and he was arrested for this. The Constitutional Court found the violation of the right to liberty and his political rights. And his release was also rejected by the local court. And finally, we will be touching upon the criminal peace judgeships. These are not the courts trying the cases and making the judgment in the merits. They deal with only pre-trial matters, but they have an extensive power from arrest to pre-trial detention, search, seizure, and interception of communications. EU Commission progress report in 2019 found out that their rulings increasingly diverge from the Human Rights Court case law, and there is no individualized reasoning. One of the reports states the following: there are relatively few peace judges, notably in big cities. This shields them from the rest of the judiciary and makes their selection by the first chamber of the Judicial Council particularly problematic. Court of Peace judges are colleagues of equivalent experience and qualifications, sharing premises and examining each other's appeals. It's possible from time to time that they tend to respect each other's decisions rather than dealing with the particularities of a case. In another report, it was detected that between 2015 and 2018, these criminal peace court judges approved almost all requests coming from executive bodies, blocking access to over 4,000 websites. So we can see no filtering and accepting all the requests from non-judicial body. And all appeals, almost all appeals were rejected by another criminal case judges. From my personal experience, I know that once the website of MEDEL was blocked. For those who doesn't know about MEDEL, MEDEL is a group of heads of judicial national associations. As I remember, 18 associations from different 18 European countries, they form now MEDEL, and it's a well respected institution whose opinions are taken into account judicial bodies. Even this website was blocked for a certain amount of time. Then I noticed that it's opened again, it's released again. Yeah, finally, we came to the Supreme Court functioning and the deficiencies about Supreme Court. In the past, before 2011, Supreme Court chambers consisted of about 7 members, and the chambers make decisions with the participation of 5 judges, not 7 judges, so that if any judge goes to medical leave or vacation, then it is still possible that the chamber can convene. But it increased in the following years up to 12 to 18 members, depending on which chamber. And this enabled the head of the court chamber to compose more than 1 committees, and the head of the chamber was able to make a decision about which members will form which committee. This may have us suspected that the head of chamber, if there is an important politically sensitive case, can form a group of judges in a particular chamber to obtain a particular result. So instead of creating new chambers with the new judges, the number of committees, subcommittees in the chambers increased. And it is claimed that it is contrary to the Article 142 of the Constitution, and also Human Rights Court case law, that courts are established by law. Even judicial bodies cannot form a new court.
Mr. Erdemli, I'm sorry, just we are running out of the time a bit, so can we
Okay, so I will
conclude? Yes,
okay.
Thank you.
All right. There's 2 more issues with regard to Supreme Court. There was an explanation, the declaration by about 100 admirals, retired admirals, regarding a statement of a member of government stating that we can withdraw from the Montreux Bosphorus Convention, and these admirals were of the view that this convention is for the use of Turkey. It increases the sovereignty rights of Turkey. And the government members strongly condemned this statement of admirals, and they said that this connotates a military coup call by these admirals. And without waiting more than 24 hours, one Supreme Court member and Supreme Court itself made an official public declaration that this statement by admirals are not acceptable, and it deserves condemnation, and it connotates a military coup call for military coup. Anyway, I need to go fast. So, in conclusion, what we see after we all examined the judicial bodies, there is a heavy political influence in the composition of the Judicial Council, and the measures taken to ensure its independence are not close, even close to being sufficient. And rather than protecting judges, occasionally, Judicial Council put pressure on judges to obtain certain outcomes from the cases, and there were a lot of relocation and suspension. And Supreme Court has not been careful to appear objectively and independent, and power of the heads of chambers to compose committees is questionable. The local court judges should question themselves if they have a culture of independence. If we need to remember how we behaved during the selection process of Judicial Council. We voted for the list of the government instead of the independent judges who were candidates in the selection process. Thank you very much for your patience. This is the end of my presentation. I am available for the questions.
So is it my turn?
Yes, Mr. I didn't know it's your turn. Floor is yours.
All right,
And then after your speech, we can take all the questions.
All right, thank you. Can you hear me all right?
Yes, we can
Yeah,
hear you.
all right,
We can
great.
hear you well.
So thank you so much. I am the last speaker and the time is pretty much late. I'll try to keep it short and simple. But I would like to say that it's an honor for me to share this forum, this panel with Professor Aybay, with honorable justices and judges from Washington State and Judge Erdemli from Istanbul. And I have learned already more than that I'll contribute. And I also need to say that I have no PowerPoint presentation, so you will need to bear with me for some time. Now, Judge Erdemli talked about the structure of judiciary in Turkey and how the independence of judges is granted by the constitutional law. As he also pointed out that there are some problematic aspects in this regard, but overall, judges and prosecutors enjoy constitutional guarantees and indeed duties to act independently and impartially in settling the disputes before them. But before touching on this matter on judicial independence, I want to talk about briefly on the individual application to the Turkish Constitutional Court. This remedy, individual application, was introduced fairly recently, yet it has become a major part of our judicial system. I believe it is fair to say that today the individual application is a significant step forward in the protection of human rights in Turkey. With the constitutional amendment of 2010, Article 148 of the Constitution was modified to provide a legal remedy for violation of rights and freedoms which are under the joint protection of the Turkish Constitution and the European Convention of Human Rights. The Constitutional Court, started receiving applications in 2012, and since then, it has assumed a direct and active role in protecting and thereby enhancing human rights in Turkey. Now, let me explain some of the basic features of the individual application system. It's almost identical to the system of the European Court of Human Rights, but of course, the application to the Constitutional Court is a domestic remedy, so that implicates certain characteristic differences. First of all, as I just said, the subject matter of an individual application may be a right or freedom which is protected both by Turkish Constitution and the European Convention of Human Rights. For example, the social security right is enshrined in our Constitution, but it's not included in the European Convention of Human Rights. Therefore, no application may be made against this right, the right to social security, because it's not covered by both texts. The second point is that individual application is an exceptional remedy. It means that before filing an individual application, one has to exhaust all other existing legal remedies. So the legal claims, first and foremost, have to be raised and discussed before ordinary courts, before the first instance and appeal courts. Only then an application may be made to the Turkish Constitutional Court. I want to give an example, a very simple one. If you, for example, as a student, the university issues a fine against a student, an administrative fine, and you think that this fine, which is enforced upon you, is illegal and it violates your right to education. In this case, you must first take action against this fine before the administrative courts and then proceed for appeal before the State of Council. And only then, if you are still not satisfied, you can apply to the Turkish Constitutional Court by stating your claims relating to the right to education. The third point is that the Turkish Constitutional Jurisdiction Court's jurisdiction is limited to make an examination based on fundamental rights and freedoms. In other words, we do not exercise an appeal review. So we do not examine if the judgment of the lower courts are right or wrong. The court makes an analysis in a constitutional framework with a focus on specific fundamental rights. So, for example, if you claim that your right to fair trial is violated, the Constitutional Court mostly will look at the procedural guarantees, if they are respected. For example, if your witnesses are heard, or if your evidence is duly considered by the first instance courts. If all these procedural guarantees are respected, the Constitutional Court will not engage in substantive analysis and examine the merits of the case, but otherwise, if there are some procedural defects, it will find a violation of right to fair trial. And the last point is that the individual application is recognized as an effective remedy before the European Court of Human Rights. So if you want to make an application before the Strasbourg Court, prior to that, you must apply to the Constitutional Court and wait the result of your application. Now, I can talk about some statistics on the individual application to give you an idea of its scale. And I want to note that unlike the Washington State Supreme Court or the United States Supreme Court, our jurisdiction is not discretionary. That means we must address every application we receive. So since 2012, the court received a little more than 300,000 applications, and it concluded almost 90% of them, 260,000. This number is indeed very high compared to the other countries having individual application. For example, in Germany, I think the average number, yearly average is 7,000, whereas it is 40,000 for our court, the Turkish Constitutional Court. So it's almost 6 times higher than Germany. But I must say that vast majority of those applications are rejected as inadmissible. 90% of them are rejected on inadmissibility grounds. So only 10% of them are being examined on the merits. And out of these 10%, only about 4% are found that one fundamental right is violated. So Judge Erdemli already gave many examples from our judgments, from freedom of expression and so on. So I'll not go into details. So quickly, I just want to say that the right to fair trial holds a significant place in our violation judgments. Indeed, it comes number one with the 9,000 violation judgments. So it's utterly important. And that brings me to the second part of my presentation, which is the relation of the right to fair trial to the judicial independence. First, I want to say, just like other respectable judges indicated, independence, judicial independence, is not an absolute privilege. In other words, it doesn't mean unaccountability. It doesn't grant to a judge to make a decision whatever she wants to. The reason of independence is to ensure that a judge acts in accordance with the law, insulated from any external pressure or influence. So the independence is not from the rule of law, but it is to apply the rule of law. So at this point, the right to fair trial comes into play, providing the procedural guarantees for the parties of the case to ensure that they receive a fair trial from an independent judge or court. I have some examples. The time is getting late, but let me quickly explain from the European Court of Human Rights. So as also Judge Erdem talked on that matter, there is an objective independence and subjective independence. The objective independence comes first. The European Court of Human Rights set out some basic principles on this regard. And one of these principles is that it does not suffice that a court is actually independent, but it must also be perceived as an independent tribunal by the outsiders, by the public. So this is objective independence. For example, the European Court found some violation judgments against Turkey in the past due to the state security courts and the high military courts. In those courts, some of the members, judge members, were the military personnel, and they are bound with the chain of command. So, in the Tanışma versus Turkey case, the court considered that the existence of such military personnel in the court panel is in conflict with the independence of judges. So the court does not engage in analysis whether these members actually act independently or not. Just the existence of hierarchical relationship stains the objective independence, so therefore the court found a violation. Another example is that if a judge or a panel of the court takes place both in the first instance and then in the appeal body, that will be a problem with regard to the objective independence. In the case of Fazlı Aslener versus Turkey, the European Court again found a violation because 3 judges from the State of Council, Supreme Administrative Court, first attended the chamber review of the case, and then they took place in the General Assembly reviewing the same case. So the European Court said this also violates the objective independence. There is a similar case decided by the Turkish Constitutional Court, Serkan Şeker. You can just check it on our website. So here, the main principle is a judge or panel settling a dispute or examining a request should not take place in the appeal process. Otherwise, that will be a problem. Familial relations may also be a problem in respect of independence. There is a case before the European Court of Human Rights, Mikalev versus Malta. Here, the Maltese court consisted of 3 judges, and 1 judge was the uncle of the winning party's advocate. So there is a familial relationship. And with no surprise, the European Court found a violation here as well. And subjective independence is some personal bias if the judge demonstrates some personal bias in the case, but that happens very rarely, so I'll skip that. There is another interesting case by the European Court of Human Rights, and this is against Ukraine. In Transavto Holding versus Ukraine case, there is a Russian company doing business in Ukraine through concession agreement. Later on, a dispute arises between the state authorities and the company, and that ends up with litigation. after the litigation, it's a big company and doing multi-million-dollar business in the Ukraine. The Ukrainian president expresses his concern over the case, and he urges that Ukrainian national interests will be safeguarded. So, indeed, the president gives some public instructions to the court. So the company loses the litigation and takes the case to the European Court, and the European Court finds a violation here because the intervention of the executive placed an undue pressure on the courts. Here, important point is that the European Court does not make an inquiry whether the judges actually followed the president's instructions or not, whether they acted independently in the concrete case or not. But the court says the pressure exerted by the executive on courts during proceedings stains the objective independence already. So there is no need to make an inquiry to the concrete case and the actual behavior of the judges. Very briefly, the right to fair trial, another sub-two elements of this right is adversarial proceedings and the right to a reasoned judgment. Adversarial proceedings is in place to make sure that the judge treats both parties equally and fairly, and each party is given the opportunity to duly present their case and defend their arguments, present their evidence, and also their witnesses must be heard. And my final point is that the right to a reasoned judgment, I think that is also very important. Judge Erdemli also gave some examples of from our case law. Here, and unlike the Washington trial courts, the Turkish courts must write the judgment and a reasoned judgment. So, and the Constitutional Court of Turkey takes this element very seriously. A judge or a court must spell out the reason for reaching his or its conclusion in the case. The reasoning should be sufficiently explaining the rationale behind the judgment and how legal provisions were applied to the facts. And the valid claims of the parties must be addressed in the reasoned judgment. So, in short, it should be reasonably convincing for both parties, and it should be suitable for public review. And in, I'm sorry, I'm losing my voice. In a prominent case of Sencer Bashat and others, the Constitutional Court laid out the basic principles on this matter. And in this case, the court found a violation in favor of hundreds of applicants. So finally, judicial independence requires a judge to apply the law to the facts with a true mind and conscience. And that must be visible and understandable through the reasoning of the judgment. And I'll conclude my presentation here. Thank you all for your attention. So, Professor Ural.
Hello.
Yeah.
Thank you, Mr. Aydın. Thank you for your presentation, and also Mr. Erdemli, thank you for your presentation. And now we are going to start to take questions, if you're ready for the questions and answers part. So first question is to Judge Erdemli, and our attendee is asking, do you think that in order to become a judge in Turkey, a requirement for a practice as a lawyer should be implemented? The judges start to do the practice at a very early age. So do you think is it an advantage or it's a disadvantage? Thank you. So your microphone is muted, Mr. Erdemli. It's muted.
Okay. The question is whether someone who wants to be a judge has to be needed to have to be a lawyer beforehand for some certain period. Is it the question? Is it?
Yes, so they're
Okay.
asking
Yeah,
starting
okay.
early is it
All
advantage or
right.
disadvantage?
Yeah, I was a judge when I was 26 years old. In Turkey, just 2 years after the graduation, 2 years of training is sufficient. Of course, if you are successful in 2 exams, which are oral and written exams. Being a judge in your age of 26, of course, is it advantage or disadvantage? I think for for a young person to be able to live your life according to your how you feel, it's not good. It's not advantage because you have to in the Turkish system. You are appointed first a small place like with 5,000 population, for example. Everybody knows that you are a judge. So you have to behave like a judge while actually you are a 26-year-old young person. In this regard, it's not an advantage. And I prefer, of course, first practicing lawyership or some other law practices and then becoming judge would be much better to see the both sides. When you are on the bench, you know that how this lawyer will think about some particular thing. Therefore, I will prefer that a certain level of professional experience is required before becoming a judge. According to my experience, even being a father and mother, having children, being quite experienced in the life, they are all a great experience to individualize your decision by using your all life experience, your experience in the profession that you did before being magistrate.
Okay, thank you.
Welcome.
And the next question is to Mr. Aydin. So they said, I would like to ask the reporter of the Anayasa Court, and the question is, while there are serious violations in our country, the violation decisions are seriously low. So is it true that human rights law is so formal and so rugged?
Yeah, well, I don't know if you follow our judgments, but we render very serious violation judgments as well. The point here is that the Constitutional Court alone cannot address every violation in the country. That's practically impossible. And the court must employ certain formal requirements because I just told about it, 300,000 applications in 9 years. It's about 40,000. I mean, 6 times higher than any average in Europe. So we must employ certain measures to filter out the unduly applications and focus on the ones that that deserves more attention. But overall, I think I told during my presentation, the court gave 15,000 judgments finding a violation. Judge Erdemli just mentioned some of them, but there are many others relating to right to life and the prohibition of ill treatment, deportation of foreigners, very serious matters the court handled, and it continues to handle those matters. But overall, we must understand that it's not only up to the Constitutional Court to protect human rights, but it's up to the whole state apparatus and the whole judiciary. First instance courts at first and foremost, and then the appeal bodies, and then as a last resort, the Constitutional Court. So I recommend to these colleagues to follow our website. We publish press releases of our judgments, important judgments, and every week 5 or 6, even though in English and even though in French. Now we started to publish. They will see that the court makes the best effort to address those issues in this country.
Okay, thank you. And third question is also for you. Which decision is taken as basis in case of conflict with the decision of the European Union Court of Human Rights and the Constitutional Court of Turkey? If the decision of European Union Court of Human Rights is essential, are there any sanctions if it's not followed?
Well, as I just said during my presentation, the European Court of Human Rights recognizes the Constitutional Court as an effective remedy, the individual application system, right? So one has to apply first to our court, and we examine the case, and then they have the right to go to the European Court of Human Rights. So they are the last resort. The Strasbourg Court is the last resort. So if one is not satisfied with our judgment, they may just proceed to the Strasbourg Court, and the Strasbourg Court may find a violation, and there are examples of that. And that's very normal, because as a national court, the apex court, we make a decision, but the European Court takes it in a different context as an international adjudication body. So I must also note that the Turkish Constitutional Court, to a great extent, follows the case law of the European Court, because they handle these matters for 50 years. They have a body of case law, very well developed case law. So the Turkish Constitutional Court considers this case law when making decisions. There is only one instance that there was a disagreement between the Turkish Constitutional Court and the European Court. And eventually, the enforcement or the compliance with the judgments of the European Court is not an issue of related to us. It's up to the government. So sometimes it has some political implications. So there is an enforcement mechanism within the Council of Ministers, within the European Council. But the point is that there is a convention, there is an international agreement, and they have the jurisdiction under this agreement. And then when they make a decision, it's binding for Turkey, that's for sure. But its compliance is a matter of the government, not with us as a court. I hope this was a satisfactory answer.
Yes, thank you for the answer. And the fourth question is also for you. It's more than a comment with a question, I can say. So they say you shouldn't try to dissolve the applications quickly just because the application numbers are high. But I understand that this will be done with your final decision. Is it true?
Can you repeat the last sentence?
Sure. What they say is you shouldn't try to dissolve the application quickly just because the application numbers are high. Mm-hmm. But as I understand that this will be done with your final decision. Is it true?
Well, it doesn't mean that we just filter out the application. We just, randomly just refuse them. No, as I just said, we don't have discretionary jurisdiction. We must address every application. And please, again, the European Court of Human Rights is there to exercise a review of our judgments, right? So if one is not satisfied with our judgments, they can just apply to the European Court. So we are not 100% review free. That's the first point. The second point, there are thousands of, very unqualified applications, many of them. I tried to emphasize during the presentation that we are not an appeal body. We do not exercise appeal review. But most of the applicants or lawyers, they just apply to the court claiming that the lower court was wrong in their judgment. That's not our business. We are not an appeal court, and the Constitution explicitly prohibits us from exercising an appeal review. So we must focus on the fundamental rights, and based on the Constitution. The Constitution sets out a framework how we can examine. I just said the right to fair trial, for example, and also we are taking into consideration the European case law in that regard. So the court doesn't make up some criteria to just sort out applications. There are set out principles, criteria, so we just apply them. And unfortunately, for example, in Germany, they require, I think they require a represented application. I mean, an application with a lawyer, so a qualified applications. That's why the number is low. I mean, if you compare our workload with Germany, it's not comparable at all. So here, this is very natural that the court, it's not because you don't want to examine them, but because the applications are unfortunately unqualified. And one last point, Germany, very similar to our court, their violation judgment ratio is about 3%, and our court is about 4%. The number is similar in Spain. So wherever you go, it's more or less the same. So it's not that the court doesn't take serious the applications, but we take them serious. We examine all of them, but we only the ones that deserve the merit review go forward.
Okay, thank you. And the last question is also for you. Does the fact that so many decisions are brought before the Constitutional Court indicate a lack of judgment in the courts of first instance and appeal courts? So they're wondering that the fact that you're dealing with so many cases is a lack of the appeal courts.
Oh, no, I mean, I didn't quite get the question, but is it about the lack of recent judgments?
No, it's a lack of, so they think that it's the failure and the lack of the appeal courts, that the reason that you're dealing with many cases and lots of cases brought to the Constitutional Court. So
no, there is an appeal court and the Court of Cassation, and they are also doing their job. I mean, there is no problem in this regard. But as I said, the individual application was adopted in 2012, so it's 9th year. So the Constitutional Court addressed many chronic human rights issues, and the lower courts and the Court of Cassation just started to observe and digest our judgments, our legal criteria, and they started to apply them. So it does not happen in one day. It takes time. So it took some time for the court to render principal judgments, case law on some serious human rights issues. And then gradually the judiciary, the first instance courts, and then the Court of Cassation, they follow our judgments. But that takes time. We had a joint project with Council of Europe regarding the individual application, the supporting individual application to the Constitutional Court. It worked very well. We made workshops and conferences, symposiums with the other courts and the lawyers and the bar unions and everything. Now we have another project. It's about the implementation of the judgments of the Constitutional Court. And on this project, we will focus on the objective effect of the judgments of the Constitutional Court. What I mean by that is, it's not that if the court gives a violation judgment on a specific issue, then the lower courts should take this judgment into consideration on the similar cases. Not every case has to come before us and we have to give violation for every specific case. Once we render the principal judgment, the case law, then the others should follow accordingly. And we are working on that, but it takes time because it's just 9 years is still a very short time to solve all problems related to human rights.
okay, thank you. We are still receiving questions, but we are running out of the time. So I want to conclude shortly and thank you for your answer. And I want to also thank to Honorable Justice Madsen and Honorable Justice Stefan and Attorney Roger Ragov and all other analysts. So I also want to take the comments if your honors has comments to make on this Turkish system or like make the closure speech for each of you, and then I'm going to give this stage to Mr. Dr. Ural Akuzov. Thank you. So Honorable Justice Madsen, we can start with you if you have your comments, and then we can continue.
This has been such an interesting conference, particularly since we have such different systems. But what strikes me is that our end goal is exactly the same: to have an independent judiciary where people who can rely on the independence and the fairness of the tribunal that will ultimately make such important decisions in their lives. And I think what I saw, the commonality is that we all want those tribunals to be independent and free of government influence, unbiased. And at the end of the day, we want the people that we serve to have confidence that they can turn to the court system when they have problems and issues that need to be resolved, and they don't need to engage in combat or take the problems on themselves with violence. And that's what everyone, I think, wants from a justice system. And it sounds to me, from hearing about your system, that you have made great strides in trying to enhance the public's confidence in your system. And that is what we are trying always to do as well. So it's been really very interesting to hear from you and on your system. And I thank you for being so candid about the flaws in your system as well, because that's how we can teach each other and we can learn from each other's problems and mistakes. So thank you so much.
We thank you, and I also was admiring you, the story, and also I want to add that I also totally agree with the Honorable Justice Stephan when she said you're a role model. Well, for us too, I'm really glad to meet you and listen to your comments and everything. So now I cannot see the Honorable Justice Stephan now. Maybe Mr. Rogov can continue with the comments if you have any comments.
I don't have much to add to Justice Madsen. I think she has said it all. I do like the discussion from one of the presenters on the appearance of impropriety as well as actual impropriety as a way of ensuring fairness in the courts, and that it is so important that the public have confidence, and part of that confidence is openness and transparency and the appearance of fairness in all of our procedures. So I again, am so honored to have been here. This panel has been terrific, and I look forward to working with you all in the future.
Thank you. And now, Mr.
Justice Stevens apologizes. She was not able to stay, so that is why she's not here. She had an obligation, and she really apologizes.
Okay, no, thank you. And now we want to get your comments too, Ms. Malat, if you have any comments.
Just that this was very, very informative and really wonderful, and I've learned a lot, not only about our system, but about obviously the Turkish system, and I'm just so grateful and honored to be a part of this. So thank you.
Thank you. It's the same for us. We're also so honored, and it was a perfect panel for all of us. Now, I want to give the floor to Mr. Akuzum for the closure.
Thank you, Çağla. It was a great moderation. I congratulate you. Honorable guests, distinguished professors, and dear participants, it was such a great pleasure to listen to our panelists, and I believe that this was a very fruitful session that enabled us to analyze the Turkish judicial system in comparison to the United States judicial system that was elaborated in the first session. I would like to thank our distinguished panelists and Mr. Çağla Arslan Bozkuş. I also would like to express our gratitude to the Rector of University, Professor Dr. Nihat Akkuş, to our distinguished professor, Professor Dr. Berin Ergin, to the Dean of our faculty, Professor Dr. Kerim Atamer, to the Chairman of the Board of Trustees, Mrs. Hülya Gedik, and Professor Dr. Rona Aybay and the Associate Professor Gülsün Ayhan Aygörmez and the platform of Hukuk Alemi for their support and contribution in this conference. And also I want to thank Dr. Elif Naz Çiftçi, a lecturer in Gedik University Law School. It was a pleasure to host you, all American friends. Thank you very much, and we have to close the session. Thank you.
Honorable guests, dear participants, all our distinguished professors, we were really pleased and happy to welcome you in our organization. And once again, we would like to thank to all of our professors and all of our honorable justices, judges that contributed in this conference. Now we came to the end of our conference, end of our session. And now I will yield the floor to the platform of Hukuk Alemi. They're organizing a drawing during this conference, so they made that drawing and they're going to give some explanations in Turkish. So all our participants who wouldn't prefer to listen to that section, they can leave the meeting if they want. Thank you very much once again. It was a wonderful, fruitful, very beneficial meeting for us. Thank you very much.
Thank you. So we can leave the meeting, is that right?
Yes, yes,
Okay,
yes, it is right, sir.
Thank you again. It was a pleasure.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you very much.
Bye-bye, everyone.
Goodbye.
Yeah. Bye, everybody. Good night.
Thank you so much. Good night.
Programımıza katkılarından dolayı kıymetli hocalarımıza ve moderatörlerimize teşekkür ederiz. Yine aynı şekilde programın yapımında büyük emeği geçen paydaşlarımızdan İstanbul Gedik Üniversitesi'ne, İstanbul Gedik Üniversitesi Rektörü Sayın Profesör Doktor Nihat Akkuş hocamıza, desteğini bizden hiç esirgemeyen İstanbul Gedik Üniversitesi Hukuk Fakültesi kurucu dekanı pek kıymetli Sayın Profesör Doktor Berrin Ergin hocamıza, İstanbul Gedik Üniversitesi Hukuk Fakültesi Dekanı Sayın Profesör Doktor Kerim Atamer hocamıza, İstanbul Gedik Üniversitesi Karşılaştırılmalı Hukuk Uygulama ve Araştırma Merkezi Müdürü Doçent Doktor Gülsün Aygörmez hocamıza, İstanbul Gedik Üniversitesi Hukuk Fakültesi Araştırma Görevlileri Elif Naz Arıkan Çiftçi ve Hazal Gül hocalarımıza, ekran arkasında ve yayın yapımında emeği geçen hukuk alemi yöneticilerimize, hukuk alemi fakülte temsilcilerimize ve hukuk alemi kurucumuz Mustafa Bey'e çok teşekkür ederiz. Son olarak Sayın Profesör Doktor Rona Aybay hocamıza çok teşekkür ederiz. Bir teşekkür de programımızın sponsorlarından British Center Dil Okullarına ve Seçkin Yayıncılığa gelsin istiyoruz. Arkadaşlar şimdi çekilişlerimize geçeceğiz. Ama bundan önce birkaç duyuru yapmak istiyorum. Hocam siz isterseniz çıkabilirsiniz. Biz çekiliş yapacağız bundan sonra. Görüşmek üzere hocam. Teşekkür ederiz. İyi günler. Arkadaşlar ilk duyurum sertifikalar ile ilgilidir. Dijital sertifikalarınız Cuma gününe kadar mesaj yoluyla tarafınıza iletilecektir. Sertifika taleplerinizi Mayıs ayının 15'ine kadar almaya devam edeceğiz. Daha önce sertifika talebinde bulunmayanlar için sertifika taleplerinizi etkinlik.hukukalemi.org web sitemizden iletebilirsiniz. Diğer duyurumuz ise sertifikalarını fiziksel olarak almak isteyenler ile ilgili olacaktır. Bununla ilgili de yine aynı şekilde hukuk alemi etkinlik.hukukalemi.org web sitemizi ziyaret edebilirsiniz. Daha önce düzenlediğimiz 9 programa katılıp onlarla ilgili de fiziksel sertifika almak isteyenler var ise yine aynı şekilde etkinlik.hukukalemi.org web sitemizden fiziksel sertifika taleplerinizi iletebilirsiniz. Son bir duyurum ise yaptığımız programlardan haberdar olmak ve yayınlarımızı canlı olarak izleyebilmek için sosyal medya hesaplarımızı takip edip Hukuk Alemi YouTube kanalımıza abone olmayı ve bildirimleri açmayı unutmayın. Abone ol butonunun yanındaki bildirim butonuna tıklayıp bu bildirimlere izin verdiğiniz takdirde düzenlediğimiz tüm etkinliklerin canlı yayını esnasında bildirim alacaksınız ve böylelikle etkinliklerimizi canlı olarak izleme imkanına sahip olacaksınız. Şimdi çekilişlerimize geçebiliriz. İlk çekilişimiz British Center Dil Okullarına yönelik olacak. Ardından seçkin yayıncılıktan seçmece kitaplar hediye edeceğiz. Tüm programlarımıza sponsorluklarını sürdürdükleri için British Center Dil Okullarına ve seçkin yayıncılığa teşekkür ederiz. British Center Dil Okullarından bir kişiye ücretsiz dil eğitim vereceğiz. 50 kişiye de %50 indirim imkanı sağlanacak. Biz burada şu anda ücretsiz dil eğitimi çekilişini yapacağız. İndirim bursu çekilişini ise dil okullarının ofisinde yapılacak. Ardından kazanan tarihlere dil okulu kendisi ulaşacak. Şimdi British Center için 1 asil 5 yedek kazanan seçeceğim. Çekilişi kazananların 5 dakika içerisinde bilgi@hukukalemi.org mail adresine mail atarak bilgilerini iletmesi gerekmektedir. Aksi takdirde ödül yedek kazananlara geçecek. Ödül kazanan yedek arkadaşlarımız da mail atarak bilgilerini iletmesi gerekmektedir. Bilgiden kastımız da isim, soyisim ve telefon numarası. Bunlar yeterli. Bahsi geçen mail adresini arkadaşlarımız birazdan yorumlar kısmına bırakacak. bilgi@hukukalemi.org. Şimdi British Center için çekilişimizi yapacağız. bilgi@hukukalemi.org mail adresimiz. Evet arkadaşlar, şimdi British Center Dil Okulları Eğitim Bursu'ndan 1 asil 5 yedek kazanan seçiyoruz. Kazanan asil arkadaşımız Cihan Aral. British Center Dil Okullarını kazanan asil arkadaşımız Cihan Aral. Yedek talihlilerimiz Ayşenur Özçelik, Sümeyye Şahin, Simge Karşıyaka, Ecem Yılmaz, Mustafa Harbi Ermiş. Şu an saat 00:22, 00:27'ye kadar arkadaşımızın ve yedek talihli arkadaşlarımızın YouTube yorumlar kısmında yazan bilgi@hukukalem.org mail adresine isim, soyisim ve telefon bilgilerini iletmesi gerekmektedir. Aksi takdirde ödül diğer arkadaşlarımıza geçer. Tekrar ediyorum. Kazanan asil talihlimiz Cihan Aral. Yedek talihlilerimiz ise Ayşenur Özçelik, Sümeyye Şahin, Simge Karşıyaka, Ecem Yılmaz, Mustafa Harbi Ermiş. 00:27'ye kadar vakitleri var. Bu arkadaşlarımızın eğer çekiliş bilgilerini iletmezler ise çekiliş diğer arkadaşlarımıza geçer. Şimdi seçkin yayıncılıktan çekiliş yapacağız. Seçkin yayıncılıktan da 3 kişiye kendilerine sunacağımız kitaplardan birini seçme imkanı vereceğiz. 3 asil 7 yedek kazanan belirliyoruz burada. Çekilişi kazananların yine aynı şekilde 5 dakika içerisinde bilgi@hukukalemi.org mail adresine mail atarak bilgilerini iletmesi gerekmektedir. Aksi takdirde ödül yedek kazananlara geçecek. Evet arkadaşlar, şu anda seçkin yayıncılığın bahsi geçen 3 asil 7 yedek seçmece kitaplar çekilişini yapacağız. Evet, şu anda seçkin yayıncılık 3 asil 7 yedek kazanan belirliyorum. Kazanan ilk tarihlimiz Sude Çankaya, ikinci tarihlimiz Furkan Köksoy, üçüncü tarihlimiz Emircan Özdemir. Yedek tarihlerimiz ise birinci yedek tarihlimiz Gökben Yücesan, ikincisi Sultan Rüveyda Ağaca, üçüncü arkadaşımız Zeynep Kaygısız, dördüncü arkadaşımız Gamze Gökçe, beşinci arkadaşımız Kadir Hakan Koyunoğlu, altıncı arkadaşımız Mihriban Alak, yedinci arkadaşımız Ecem Çıkırkoğlu. Bu arkadaşlarımızın 00.30'a kadar bilgi@hukukalemi.org mail adresine isim, soyisim ve telefon bilgilerini iletmesi gerekiyor. Aksi takdirde ödül diğer arkadaşlarımıza geçecek. Tekrardan asil kazananlara tekrar ediyorum. Sude Çankaya, Furkan Köksoy, Emircan Özdemir. Yedek kazanan arkadaşlarımız ise Gökben Yücesan, Sultan Rüveyda Ağaca, Zeynep Kaygısız, Gamze Gökçe, Kadir Hakan Koyunoğlu, Mihriban Alak, Ecem Çıkırıkçıoğlu. Bu arkadaşlarımız 00.30'a kadar bilgi@hukukalem.org mail adresine bilgilerini iletmezler ise çekiliş haklarını kaybedecekler. Bu güzel programı baştan sona izlediğiniz için ve vakit ayırdığınız için hepinize teşekkür eder. İyi geceler dilerim.